Yes, please.
Without the certified copy. Leave be granted but to file the appeal without the certified copy.
Appeal from?
Appeal from an order of the on a single bench is a matter of determination of court number 13.
Court number 13.
Is well the group 5 matter. Group 5 matters.
Why you are mentioning here?
Well, because the determination possibly yesterday the determination of
Unless I know, I cannot entertain.
no, if it is not the determination has not been
Unless we do not know, how can we?
very good.
Only when we know, then we can.
Yesterday when it was yes, I will ascertain then I'll come.
Find out, please. Yes.
Matter from tribunal matter, my lord. Extremely urgent. Yes, Monday order was passed. Yesterday it was made on server, my lord. I am coming. My lord, tomorrow is the date of interview. My lord, petitioner's candidature has been rejected on the ground that the qualification he possesses is not recognized by by the government of West Bengal. My degree is from West Bengal State Council Department of Technology.
What the tribunal has done? What has the tribunal done?
Well, tribunal, we prayed for an interim or a tribunal just said the matter is admitted on and gave the date in the month of November. Nothing. My submission not recorded, nothing done. My lord, today I want to move this matter today. Previous year, my lord, for the same recruitment process, the Honorable Tribunal, Division Bench of the Honorable Tribunal granted me and passed a rescind order that this person should be with this qualification, this person should be allowed to participate. The government accepted that order. Again, this year I was rejected. I moved the tribunal. The tribunal did not even consider the coordinate bench order of the today at my lord at 2 p.m. or 3 p.m. Otherwise, my lord, this is my last chance. Otherwise, thereafter I will be H-bird.
Take it 2 p.m.
At 3 p.m., my lord, I will serve and come back.
Just a minute. Oh, 2 p.m. this bench is not available.
My lord, any day at 1 I will serve and come.
At 1 will take you inform the.
My lord, I am serving. My lord, I am serving.
Unless they are here, we will not pass any order. You please.
My lord, only one thing. If your lordship directs your lordship officer written that matter will be taken up today at 1 p.m. Then only the department will accept the service, my lord.
So what do we have to do? We are saying so.
No, my lord. If the officer will leave granted to move the matter today at 1 p.m.
You please see if the other side is not here, we will not pass any order. We are letting you know.
At 1 p.m.
Yes.
For restoration, my lord.
Yes, next week. Any day next week.
Well, I am trying to ascertain whether the
All the list.
Item number 1.
Maybe that's available.
This matter, my lord. Annexment as the petitioner is claiming the provident fund of the deceased as a nominee. And on last occasion, I submitted that my client, son of the deceased, has the succession certificate. In that view of the matter, my lord asked me to contact with my learned, my client for getting instruction.
Yes.
He got the instruction, my lord, but he want to settle because he is claiming at present there are two claimants and total amount money. But what actual the proportion, the ratio at which the amount may be
That you can decide. See,
that can be decided, my lord, in presence of the
in
clients,
presence of the parties,
parties.
if they will,
Learned
they should
cannot,
both.
neither of us. My lord.
They should both understand who needs the money more and how much
That is-
one
that is-
needs.
That is the
That they
difficulty.
can work
That is
out.
the difficulty. I have convinced him that both of them should enter. My lord, that is the law point, actually, legal position, actual legal position. You understand the legal property? Something more.
And you are for the state. So it is a tussle between the petitioner and respondent number
Respondent number 5.
5. petitioner claims to be,
Nominee,
The sister of the deceased.
sister of the deceased,
and you are son.
son of the deceased.
My lord, if your lordship before, my lord, if your lordship permits me, my lord, I just want to bring to your lordship's notice a provision which provides for apportionment and the share in which it has to be done, my lord.
So there is a contest,
There is a provision, my lord. If your lordship sees it just once before dictating the order, my lord,
and the her sister of the deceased is held to be a family.
covered within the minute. So
That
just use the
is-
provision once and then your lordship may decide.
And that is an admitted position.
There is a provision. No, no, not at. There is a matlab, provision, my lord. There is a provision. In the
He is
DCRB,
not interested.
So DCRB rule does not apply in that work.
All right, then you are not interested, then we'll hear this one.
acutely interested.
Huh?
My lordship is doing so much for this client, my lord. Like, why will not be interested, my lord?
No, see, we are not going to enter into entitlements. Once we have asked him to come back with instruction in your presence, whether you are willing to settle.
Yes, my lord.
If you are not willing to settle, we have no difficulty. We will consider the matter on merits. You can contest the issue.
I don't want to, my lord. Since your lordship is passing an order, I thought it best, lord, to bring the
Those things, let them decide between themselves.
already
They
your
will-
7 years are gone. I am already above 60, my lord.
Therefore, all the more better that it should be settled once and for all instead of
That's
both.
I have.
Let us see what happens.
Item number 2, I appeal for the appellant. On the last occasion, your lordship had granted us liberty to not carry out an amendment because the respondent number 1 in the appeal has passed away. Well, we wrote to my lord the heirs of the deceased as well as the advocate appearing. They've received the letters. They are not providing us with the necessary death certificate for me to apply in the form of a substitution application, my lord. I don't know how to go ahead with this. Because the respondent number 1 has died on 13th of July 2025.
And you are?
Well, I am the appellant.
No,
And I have suffered the order, my lord, in the
how
court.
are you related to this respondent?
My lord, we are brothers in effect.
And you don't know
My
the details?
my aunt's son, not siblings.
And you don't know the details?
But I know the details as to a date, but my lord, for applying, my lord, we have to put the death certificate as well. Lordship, if I can apply without it, my lord, that is the only problem. Because the pleading has to go in, and in terms of Order 22, Rule 10A, my lord, the pleader has to indicate to me with the document. I've written to him, my lord, he has received the letter from our end, but they are not providing us with the necessary document, nor are they.
Who appears for the other side?
My lord, Mr. Gopal Ghosh, who's a senior advocate, he used to appear. Mr. Banerjee was the advocate on record. This is the third time actually, my lord, because on the first occasion they intimated, we requested, they didn't do anything. Now we have officially communicated to them, they haven't responded.
Apart from the son, there is nobody else.
No, son and daughter. We know that there is a son and a daughter, my lord. But my lord, without that death certificate, my application will become infirm.
In paragraph 7, you have mentioned,
Lordship?
in paragraph 7
Yes, my lord.
of the application, you have mentioned the name of.
But that application is there. This is another person who has passed away.
That has not been disposed of.
That's been disposed of. No, that's not been disposed of. No.
They can
My
indicate
lord, when this application was filed, the respondents appeared and said that the respondent number 1 has also passed away, which we are aware of. So we requested for, my lord, a document.
You know the names of the legal heirs.
Yes,
The
my lord, we
deceased.
do.
Make an application.
Date also.
We'll in the application then we'll pray for dispensation of production of, my lord, a copy of the death certificate. What else can I
Do
do?
we have to tell you this? Whatever is the procedure in this
We'll-
circumstance, you have to go by that.
Because they are not cooperating, because it is in their benefit.
We don't know. That is what you are saying. That's one side of the story.
No,
Maybe right, maybe wrong. We don't know.
No, my lord, absolutely.
But the point is, if you are in knowledge, you have the date. Just because
do
a
that.
certificate
We'll
is
do
not there, why should you postpone
We'll do that.
filing of the application?
No, absolutely. We'll do that.
How much time you'll need?
A week's time, my lord.
Let steps be taken in terms.
Item number 3.
My lord, I am the petitioner of tender of mandamus appeal, number 1806 of 2024. Sir, this is the essential document, a farm affidavit in Honorable High Court. So, my lord, may kindly accept it. This is the essential document. So, just now I submit in this Honorable Court for this regard, and tomorrow already I have seen the letter which has been issued by the secretary. So tomorrow I will submit these documents, and just now I submit the supplementary affidavit. May kindly accept it.
Why are you filing the supplementary affidavit?
Yes, my lord, already I have filed an FR affidavit in rebel court, and this is the essential documents for uh, tender of mandamus appeal. So now
This,
submit these documents. My
these,
may kindly accept it.
पहले सुनिए क्या
these documents were part of the record before the tribunal. Were these documents part of the record before the tribunal?
Yes, my lord, this is the essential document. Already I filed the tender of mandamus appeal. So it is essential for me and copy served to the learned council. So my lord, may kindly accept it. I am the old person. It is very
See, if
documents, my lord.
you,
May
we
kindly
can't
accept.
communicate with you. How do we say we don't know how to interact with you? We are asking you whether these documents were part of the record before the tribunal.
single the High Court Lordship, it was not from the trial.
Yes.
What? Yes.
দাঁড়ান লিফটটাকে আগে ডিলেটা কন্ট্রোল করুন
We have to have somebody to help you.
Kindly
Need to
delete
have somebody to help. How can we proceed, sir, like this? We cannot communicate with you, then how can we proceed?
Or
It is just by you. If you start saying just unilaterally, then that is not going to serve any purpose. You have to hear us also.
Sir, 1 year passed away, the Honorable Chief Justice and companion justice sent this for justification in 3rd September 2024.
Yes, and yesterday you have finally recurred all the defects. We are unable to
Oh,
interact with you.
Some
How do we
essential
proceed?
documents, just now, sir, I am
जी।
produced it. So, already.
We are asking you
documents
whether
already
this.
FR
बोलते हैं पहले
in court.
सुनिए जज साहब का बात सुनिए पहले उसके बाद बोलिए
हाँ,
How to deal with this situation?
जो डिले का जज साहब का बात सुन लीजिए उसके बाद हम बात
हाँ.
आप सुन सक रहे हैं हमारी बात?
हाँ सर, सुन रहा हूँ.
ये जो आप फाइल करना चाह रहे हैं,
हाँ,
ये कागज ट्राइब्यूनल में था ये सब?
हाँ सर.
वो एक अपार्ट है?
हाँ,
This is a mandamus
उसी का पार्ट सर, कुछ एसेंशियल डॉक्यूमेंट इसमें.
बिफोर द ऑनरेबल
सभी-
सिंगल
हाँ
जज।
जी सर, इसीलिए.
ये रिट का पार्ट है, रिट में था ये,
हाँ,
तो अलग से क्यों फाइल कर रहे हैं?
ना सर, कोई चीज अलग नहीं है. इसलिए सर इसको मैं अपने टेंडर ऑफ मैंडेमस अपील जो फाइल किया 1806 बहुत जरूरी है. और
ये तो कंटेम्प्ट से आ रहा है ना ये
हाँ,
बात?
कंटेम्प्ट जी सर.
कंटेम्प्ट में ये सारे डॉक्यूमेंट
हाँ,
थे?
जी जी सर. कंटेम्प्ट के साथ ही में इसी में कुछ ऐसी बात छूटी हुई है जो इसमें है सर.
नहीं,
इसीलिए-
इसमें बात
हाँ।
उठी है कि नहीं, वो हम आपसे नहीं पूछ रहे हैं। हमारा ये आपसे पूछना है,
तो सर
ये कंटेम्प्ट जो आपने फाइल किया था उसका ये उसमें ये सारे कागज थे?
कंटेम्प्ट में जो फाइल किया हुआ है सर, उसके अलावे भी कुछ ऐसा एसेंशियल डॉक्यूमेंट्स
वो नहीं आप दे सकते हैं, वो आप नहीं दे सकते हैं, वो आप नहीं दे सकते हैं। जो कंटेम्प्ट में था वही आप दे सकते हैं।
नहीं नहीं, कंटेम्प्ट का ही चीज है माय लॉर्ड. इसमें भी कंटेम्प्ट का ही, दूसरा कोई चीज नहीं है माय लॉर्ड. इसलिए एक्सेप्ट कर लिया जाए माय लॉर्ड.
ऑलराइट, टेक इट।
I am old person and I came this course for justification, my lord.
One voluminous supplementary is being filed by the बोलिए। Now he's going.
The order passed in the contempt proceeding, Lordship. If your Lordships come to my compilation, that is at page 106. The order dated 13 September 2019.
13?
13 September 2019.
Or is it 8/8/24?
Lordship, those are subsequent orders, Lordship. Everything has been challenged right up, right till the time of payment. But the initial order, Lordship, is 13 September. That is also under challenge.
No, but today this appeal arises out of an order passed on 8/8/24.
And all the I'll just memo Lordship, I'll just see. Nah, memorandum of appeal. Papers. No, also 13/9. That is also under challenge. He challenged 13/9, 12/7/24, 8/8/24. 3 orders are under challenge.
Yeah. Thirteen nine nineteen passed in the same contempt proceedings,
Passed in this contempt.
and 12/7 also passed in the contempt
Yes.
proceedings,
These are all in the same.
all arising out of CPN 1023.
All arising out of
Cannot be, because CPN is of 23 and first order is of 2019. So
Yes,
how it
Lordship, this was the order which was to be complied with.
Oh.
13/9. 13/9 order.
So that was an order passed in the writ proceedings.
No, that was passed in one contempt proceeding, which was dropped. Thereafter, he filed because there was a mistaken calculation of his pensionary benefits. We admitted that mistake. And then the second round of contempt was because it was not being paid. Then the COVID and everything, Lordship, thereafter, the delay in payment gave rise to another set of proceedings. Lordship. And that was
There is the order of 13/9/19 in this compilation that you have.
page 106, 106. Lordship, that will make things clear, Lordship. Come to Which one? চাইলেই পারতে চাইলে পারতে ব্যাস তাহলে এবার
Where is the next order?
Lordship, the next order, even in the, it's, the next order is
12,
alternative.
12/7/24.
Lordship, then 8/8/24, Lordship, that is when the contempt is dropped. Because, page 116, Lordship, 16 of the compilation, that is when the,
Oh, this is not 12/7/24.
no, this is the 8th of, 12/7/24. Memorandum stated ছিল আমারটা আবার মিস করে গেছে কেন 27 97 24 আচ্ছা বোধহয় কিছু এই টেস্টে আসবো
It is at the last of the memo.
লাস্ট অফ দ্য দ্যাট ইজ the memo
Why this has been challenged? This is only for
Lordship, these are the orders.
ये जो ऑर्डर जिसके खिलाफ आपने अपील दायर किया इसमें क्या है गलती?
आप इधर देखिए। बुझा
My lord, may kindly see page number 366. Department called me when I was posted at Manipur or Chandpur. Department called me to battalion headquarters at 56 APO, Kashmir. When I reached that location, commandant called me in office.
memorandum of
And
appeal का
MS Badiana, commandant, called me in office and forcefully issued the pre-metro retirement from service. Two officers, assistant commandant, signed on that paper, and also your petitioner signed on that paper. And I received this a letter from the authority concerned, and again I filed again challenge the impugned order of Honorable Supreme Court. The Honorable Supreme Court, my Lord, SP Parocha and Honorable Justice in third September, no, 3rd November, the Honorable Chief Justice, Honorable Justice SP Parocha and VN Khere passed an order, then writ petition. This means for liberty to petitioner to file an application of writ for same relief. For this regard, my lord, I file a writ application WP 915 W of 1999, and also filed a contempt application CPN 495 of 400 of 99. So, my lord, this order passed by the Honorable Chief Justice on that period, and Ashok Kumar Das Adhikari. My lord, Ashok Kumar, Justice Ashok Kumar Das Adhikari issue the rule and direct the Director, Secretary, Ministry of Home Affairs, Government of India, Director General, Inspector General, Deputy Inspector General, and Commandant. They personally attend the court of time of the hearing the application. But my lord, the advocate of Learned Council of Union of India, they submit AIR that the malaria department, the international disease, for this regard, the respondent did not appear. So, my lord, Dr. Sambhuta Chakravarti and Jaimal Bakshi, my lord, accept the rule and already passed on order. For department, again filed and a special petition in Supreme Court, court number 12. I was present there, my lord, and I engaged a senior lawyer, Paramanand Katara, and on that period, my lord, Justice in Supreme Court, my lord, they remit this matter in an Honorable High Court at Calcutta, and Honorable Justice Das Adhikari. I was present there, my lord, but already he had passed an order that petitioner is not present. For this regard, this matter already is so. But my learned counsel already filed an application of Honorable Supreme Court. The Honorable Supreme Court passed passed and judgment. This judgment already annexed in Korean Joseph and Korean Joseph and Honorable Justice uh, already the leave granted, pass an order and petitioner get financial benefit. Pass an order, my lord. Page number in contempt
Achha,
application,
87.
page number, my lord.
That order is at 87.
Page?
87 of the compilers.
So, my lord, I received a excellent awarded from different parts of India. And at present, in the last occasion, my lord, department issued the preliminary order. So, my lord, your petitioner challenged the impugned order which was passed by 31st August 1996. The Honorable Justice Kapobrata Chakrabarti, my lord, quashing the premature retirement in Honorable Court and pass an order, then prisoner get 71 lakh with interest, and department promote him according to seniority basis, because this appeal already dismissed by Honorable Justice in division bench, my lord. Satyaprat Sinha and Devendu Bhushan Datta already dismissed the application which I filed by Union of India in 1988, my lord. And now this matter already decided in division bench, then petitioner according to seniority basis, it is the rule allowed, and petitioner according to seniority basis, petitioner entitled for promotion. So, my lord, my juniors MD Shukla and SP Tripathi promoted at the rank of commandant, and they retired from service. So, according to seniority, I am entitled for promotion as a rank of senior grade commandant. And my lord, may kindly fix the pension as a rank of senior grade commandant, as your lordship pass an order, your lordship found fit and purport. This is my last petition in this honorable court. Now I am 83 years old, my lord. I am unable to, my pecuniary condition is very miserable. So, my lord, may kindly consider this matter, and this is my last submission, that your lordship maybe consider this matter and decide. This is the Honorable Chief Justice and companion justice already say as this is the assigned matter, my lord. May kindly consider this matter as your lordship found fit and proper. This is my last.
You want pay scale of commandant? You have already been allowed the pay and promotion as head constable with effect from January, because you were claiming disparity with others juniors to you. जनवरी 86 से तो आपको मिल गया हेड कांस्टेबल का ना, 1986 के जनवरी से हेड कांस्टेबल का तो आपको बेनिफिट मिल चुका है कोर्ट के डायरेक्शन के हिसाब से, तो अब बचता क्या है आपको?
This matter already quashed by honorable court, my lord. Honorable Justice Tapobrata Chakrabarti, my lord, already quashing this matter, and so, my lord, I am entitled.
आपको अभी क्या चाहिए ये पूछ रहे हैं हम आपसे, क्या चाहिए आपको? क्या चाहिए आपको?
वो बोलिए
Oh, sir, I am may kindly fix the pension as a rank of senior commandant, and my due. I am entitled for in 1996, 1997, 1998, because service has been according to already I submit the AIR 1987 Supreme Court, Manmohan Singh Chopra versus Punjab and Haryana, and 1983 Supreme Court, Devkinandan Prasad versus Justice of Bihar. Already I refer this matter, my lord. So I am entitled for amount of 71 lakhs with interest, and I am entitled for promotion as a senior, because my juniors already promoted as a rank of senior grade commandant, and they retired from service. So, my lord, I am entitled for that rank, and my pension, my lord, may kindly fix as a rank of senior grade commandant according to seniority, because the appeal which has filed by Union of India, this appeal already dismissed in 1998, 17th March 1998. This matter already dismissed by Honorable Justice Satyaprat Sinha and Devendu Bhushan Datta. So, rule allowed.
That appeal was arising out of WP 915.
According to seniority basis.
Which appeal he is talking about?
Title.
Lordship 915 appeal, I find.
Mandamus appeal का नंबर क्या है?
Appeal
Old estate, my lord, as your lordship pass an order your lordship found fit and proper.
मैंडेमस अपील का नंबर क्या है?
Order dated 21/5 and wait, mandamus appeal का number क्या?
हैं?
Mandamus appeal जो आप बोल
जो आप अपील दिखाना चाह रहे हैं ऑनरेबल जस्टिस एसबी सिन्हा साहब का,
वो जो अपील का बात आप बोले नहीं अभी,
हाँ,
उसका नंबर कितना?
oh, 1987, already I have submitted.
Lordship, I think it's page 72.
1987 Supreme Court,
Lordship,
Birjmohan Singh Chopra.
Lordship, page
versus
73, the
State of
order
Punjab and
starts.
Haryana.
This
Yeah,
is
yeah.
arose out of WP number 915. 72, Lordship sees. This
oh,
is
this is out of 915.
915.
But this is not by His Lordship Justice SB Sinha. He is saying some judgment of
Right.
Lordship SB Sinha.
Appeal number.
This is Justice D.K.
AFM.
Shet.
Appeal number.
I don't find
82
anything
of
of Justice S.B. Sinha
1994.
here.
This point already registered.
Lordship, I don't find
Huh?
any. I don't
AFMA
find.
52 of 1994.
That is
94.
By
Lordship, please.
Honorable Justice Satya Sinha and Devendra.
नंबर उस केस का नंबर क्या है?
इसका नंबर
Case का नाम.
इसका नंबर
oh yes का नंबर my lord AFMA
हाँ,
52 of 1994. This is the number of appeal which has been filed by Union of India.
ये डिसमिस हो गया
Yes.
तो अच्छा ये कहाँ इस have you got a copy? Have we got a copy of this?
To look out on that, Lordship. I started from, I didn't check the
Senior
previous one.
commandant, there is any order that he has to be given the benefit of senior commandant?
Lordship, senior commandant, I don't.
915 order I have just gone through.
Inspector, he was given. Lordship, please. 90, Lordship, I'll just check. 89, there was original order. I'll just check.
सीनियर कमांडेंट का पड़ेगा
कौन सा ऑर्डर है बताइए?
The Honorable Court decided this matter that according to seniority basis, Satya Sinha appeal FMA 52 of 1994 filed by the Union of India Department of CRPF. So this appeal already dismissed, which have been filed by Union, and the rule allowed and
1994.
according to seniority basis, petitioner entitled for promotion as a rank of because my juniors already promoted as a rank of senior grade commandant.
Which junior? कौन? किस?
For promotion in that rank which has been obtained by the juniors.
दोनों जूनियर का नाम बोलिए.
हाँ, my lord, may kindly write it. M.D. Shukla, he was appointed in 1970. 1 year junior, my lord. I was appointed as a head constable in 1969. So, my lord, may kindly M.D. Shukla and S.P. Tripathi. Two juniors promoted as a rank of senior grade commandant and they retired from service as a rank of senior grade commandant. So I am deciding for that. M.D. Shukla and S.P. Tripathi.
And inspector to the post of Lordship will kindly find, Lordship, what my learned friend, what he's saying, Lordship, page 110, paragraph 5 of the order dated 13.
No, see, he is claiming that whatever was the dispute, he was out of service for some time. What we could gather from the records. After orders passed in his case, he was back in
He was
service.
back in service.
Now, coming back in service, he has been paid some dues which, according to the Union of India, was due. He raised an issue in 915 saying that this MD Shukla and Tripathi though they are juniors to me, they have been given the promotion to the post of head constable with effect from January 96, whereas he has been given from 1988, April 1988. Please come to page 112 of your compilation, paragraph 10.
As produced.
That sums it up.
However, from the documents as produced on behalf of the alleged contemners, it appeared that one MD Shukla and one SP Tripathi were both appointed in the post of head constable on and from 16th May 1970 and were thereafter promoted to the post of inspector on and from 17 January 1986 and 16th April 1988 respectively, whereas the petitioner, though appointed to the post of head constable prior to them in 20th August 1969, was given notional promotion to the post of inspector with effect from 1st April 1988. In view thereof, the learned additional Solicitor General was directed to avail instructions as regard grant of notional benefits of promotion to the post of inspector to the petitioner with effect from 17 January 1986. Thereafter, supplementary affidavit was affirmed.
Then you accepted this position.
Paragraph 3 of the supplementary affidavit.
So you accepted this position that
Lordship,
yes,
that
those
is-
persons were promoted as inspector prior to him, and then this court directed in paragraph
Then we
15.
had granted him, Lordship will
No,
kindly
come
read
to
out.
paragraph 15 of that order.
Ah.
So therefore, his promotion was antedated
The
to
said
give him.
record, Lordship has come to the knowledge. We admitted it and we have adjusted
Correct.
the
So
rest.
there you gave it with effect from 86,
We gave it with
and the
effect
money
from-
was also
Also
directed
paid.
to be paid. And then there is a recording in the contempt proceedings that money has also been paid. We don't find anything about senior commandant anywhere.
This is something I'm hearing today also for the first time.
Problem is he has some
Line only
grievance
margin.
which is very dear to him, and we don't know what he's trying to say. We are unable to make out. And he's just adding volume to the records, which is
Because
making
he's-
it impossible. We don't know how to deal
Lordship,
with him. It's
What
impossible
my
to communicate
compilation,
also.
Lordship, actually, there was an order dated passed in 1988. That will give the picture clearly.
Where is that?
I'll show you. I think that helps. It's not very. So, I mean, while deciding, this is page 26 of the opposition. This is where he got his reliefs. It starts from page 929.
This is perhaps the order by which he was reinstated.
That is that gives the whole background. Maybe that will be make things clear because Lordship there was absolute. Then there was a stay.
So in compliance of this order, he was promoted with effect from 88.
Notional benefits.
And then he came to this court saying that others have got it since 86.
And we gave that order.
And then you considered on
And-
that. Now he has got the benefits from 86.
But the
But all of this is only about inspector. From where is he?
what he actually wants, Lordship, what I've understood all these years is he was granted notional promotion. But he wants the financial benefits. He's
No, you
claiming
have given him benefits, financial benefits.
on the basis of a notional promotion.
Yes.
Or he wants the actual wage.
No, he's saying senior commandant.
Now
The
he's saying,
benefit he has
Lordship-
got is for
Lordship,
inspector.
Now he's saying that.
Oh, I have get it. No,
But what that is the problem. This is where Lordship he's not clear. The promotion was notional, and he's wanting the actual. He's calculated what he should have got at 71 lakhs something odd, that is whatever he's claiming. That is what he has wanted throughout. But the promotion was the notional right from 1988. He was reinstated, given promotion. We have also adjusted that, given him the adjusted amount. That is how, therefore, in this contempt, that nothing remains. What he wants is the actual benefits which were notional. That is what
No,
really
he is not asking for that.
That he's asking now today, Lordship.
No, he is saying senior commandant. He wants the benefit of the post of senior commandant.
Yes. Now, but Lordship will kindly see in the orders, senior commandant is not.
We are unable to find anything reference about senior commandant in any
That
order.
is that, Lordship. I just check the order, because in the order dated 13 September, it has been
In that
given out
order also, there is no mention of senior commandant. We have just gone through it.
Lordship will kindly come to the
So this MD Shukla and SP Tripathi, were they promoted as senior commandant?
MD Shukla. No, sub-inspector to the post of inspector.
That we have seen.
That
But
is all. We don't, that is what I'm saying. This has come out today. I mean, I don't have the senior commandant.
when Mr. Dasgupta, can you please help us for a minute? Please ask him on which date this Shukla and Tripathi have been promoted as senior commandant.
किस तारीख से प्रमोट हुए थे आते हैं?
Promotion का तारीख as a rank of commandant.
हाँ,
Commandant.
हाँ.
Sir, already he retired from service in 1996. So my colleagues did not claim, but they promoted it. This is the
प्रमोट उससे 2-4 साल पहले हुए होंगे ना?
हाँ, yes sir.
कब रिटायर हुए?
वो रिटायर हुए सर 2006 as a commander.
रिटायर हुए.
And 2007 में
रिटायर
2006. Both of them retired in 2000. 2000.
एक 2006 एक 2007.
ये
One is
शुक्ला साहब 2006 में
yes.
और
MD शुक्ला
कितना वो बोलो. शुक्ला जी कितना 2006 बस.
2006
और त्रिपाठी जी
and SP Tripathi, my lord, he retired from service as a senior grade commander in 2007.
आप कब रिटायर किए?
My date of retirement is 2nd February 2006 because 1 year I am senior from.
हाँ नहीं ठीक है. आप 2006 में रिटायर.
Department. I was appointed as
नहीं आपका रिटायरमेंट कब हुआ?
and 19 and 31st August 1996 they forcibly retired from service as a rank of head constable. I was appointed as a head constable.
आपका नहीं समझ गया. आपका एक्चुअल डेट ऑफ रिटायरमेंट क्या था अगर आप रहते सर्विस?
हाँ 24th February 2006.
तो ये जो रिटायरमेंट आपका हुआ 31 अगस्त 1996 में, वो कभी वो कोर्ट आए थे आप ये बात लेके कि वो गलत रिटायरमेंट हुआ आपका? 31 अगस्त 96 को आपका रिटायरमेंट गलत हुआ, ये कभी कोर्ट लेके आए थे? कोई आदेश है इस विषय में?
जो रिटायरमेंट कराया जबरदस्ती आपको, वो आपने कोर्ट में आके चैलेंज किया कभी?
Yes.
तो कहाँ आदेश?
Already I have challenged the impugned order of Honorable Supreme Court.
नहीं सुप्रीम कोर्ट का नहीं. आप ओरिजिनल कब पहली बार कब चैलेंज किए? आपका जो कंपल्सरी रिटायरमेंट था, आप पहली बार कब चैलेंज किए? कौन से रिट पिटीशन?
Read petition 900 WP
915
915
or 915.
1999.
67 Lordship.
That is the order we are going through.
That is the order.
in this Honorable Court.
915. Where is the order passed in 915?
हाँ हमको मिल नहीं रहा है.
नहीं
Where is the order passed in 915?
Lordship, page 67 of the compilation. Page 67 of the compilation.
This is a CP 3190.
Lordship,
Page
this is WP 915W. Lordship sees page 67. This is the order dated 31st of July 2001.
Yes, it is 31st. Oh, yes, at the
Yes,
top
that-
it says 915. No, but this is probably 67.
67.
366.
360.
Onar compilation 360.
No, for the sake of convenience, because this has just become voluminous, we had requested that please compile all the orders chronologically so that we can go through it. Oh, so this court in 915 reiterated the order passed in the 1988 order. इसमें तो कहीं सीनियर कमांडेंट की बात आपने की नहीं है 915 में. This order was also challenged.
Lordship, this order, Lordship, then a contempt was, Lordship, this order was,
This was perhaps challenged by you.
there was a modification. Lordship, the writ petition, there was an application for modification. And here we, Lordship will kindly come to page 70. After that order, what happened? There was a can which was filed on his behalf. There was an application for modification, and there the observation is the petitioner has been extended all retirement benefits which are available to him in terms of my judgment and order dated 31/7.
So in these proceedings, he has not challenged this order passed in 915.
No. And
Yes.
then it was only the delay which he did not submit papers, and that was sorted out, Lordship.
Where
He's
is
directed
senior
to submit
commandant? We
pension
don't find
papers.
even the mention of this post anywhere in
It's
all
come up
these orders.
This has come up today because what he was really, what his focus was, he feels he's entitled to. Lordship will kindly come to, his submissions have been recorded. By Lordship will kindly come to paragraph 4 of the order dated 13th of September. That records what he really wanted.
Yes.
On the basis of, Lordship, the last line sums it up. On the basis of consequential fixation, the petitioner becomes entitled to amount of 71 lakhs. This is his contention throughout, Lordship. Lordship sees paragraph, it starts from paragraph 4, page 110, paragraph 5. His detailed submissions have been recorded.
See, but this amount that he is saying today remains the same. 71 lakhs, he says I am entitled to. But in this order, which has been passed, the court has recorded that this amount is due to him because these two gentlemen have been promoted as inspector
Lordship,
from 86, whereas he has been promoted as inspector in April 88. Today he is saying senior commander.
That is not that. This was actually his driving force was this amount he wanted. Otherwise, the senior commandant issue he's raised just for the first time today.
Yes.
Because all these years I've been 13 September. Because I mean, this is off the record.
And
During the
contempt of the
arguments,
contempt arising out of
during
this.
the arguments, it was his contention that as the court had recorded his submission, it was he was under the impression that court had asked to give him that. So that was because he was.
I'm sorry,
the court had recorded his submission.
yes.
And
Oh,
on the basis of consequential fixation, the petitioner becomes, that was his submission. Therefore, he was under the impression
that this is
that
the
was the
direction of the court.
That was the direction. That is why these contempt applications. But what was to be paid was the difference of fixation, 88, 86, which we had corrected. But
now he has put to challenge this order also.
Lordship, that is, I mean, That is a new case coming out.
And he says senior commandant.
No, but
we don't know how
Lordship-
he's saying senior commandant.
Then if your lordship, I'll go through all the documents if I find any senior commandant anywhere, but that was not the
We need help because problem is
I understand that.
communicating
That is
with
what
him
I
is that
we can't.
we have got a bird's eye view of everything, but from where he's getting this senior commandant issue?
Lordship, I'll check through the compilation, which has started much. I mean, it has been it's much earlier, right from the initial period. I'll see if he's ever made a claim.
Can you help
Or
us?
if Mr. Dasgupta can help me out, because I'm.
No, we need an amicus. We need an amicus in this matter. We are serious because see, he has a conviction that must get this. So he must know that he will get it or he will never get it. Whatever it is, we have to decide. So if you can help,
It's me as an amicus then, because I appear on behalf of case
CRPF.
CRPF.
you are normally appearing for them.
But lots.
Huh?
You're not
What is that?
amicus. Amicus. The lordships can appoint him as an amicus.
Yes,
That
yes,
is-
once.
That is not going for any. No, amicus.
There won't be any conflict. It's not professional. You will be assisting the court.
He's not appearing for him. He's an amicus.
Then I can.
He can do it.
If he will request you just to have a discussion with him today before he leaves, if you can, or if he wants to come back, we don't know, because then it will become very difficult. Just pinpoint the issue so that we can deal with it.
Pressure before the vacations. यही रहता कलकत्ता में रहता कलकत्ता में
দেখ বসে যাবেন হাইকোর্টেই বসে যান ও থাকে ও আসে
ঠিক।
এখানেই বসে কথা বলে নিন আর আমি কম্পাইল
No, we are going to consider your convenience. You please tell us how you can do it.
Yes. ठीक
এটা হয় যখন হয় এতদিন শেষ করে
Can you give me 1 day?
One day during the proceedings to
I'll tell him.
এইটা একটা কি আছে কম্পাইলেশন আছে এই এটা দিয়েছি যে দিয়েছি তো এই যে কপি টু
ये जो आपको दिया था कहाँ है? ये कॉपी आपका कहाँ है? ये जो आपको दिया था,
कॉपी रिसीव कर लिया तो आप
दे दिए
किसको दे दिए? ये तो आपको दिया गया था।
अच्छा
वो
तो
मेरे
घर
घर में है।
घर में আমি আমারটা দিয়ে দিই
ঠিক।
It's better.
ইন্দ্র,
ঠিক আছে
আজকে ডকুমেন্ট ফাইল করেছে তার কপি
তারপরে কিচ্ছু করতে হবে না এইটা দেখে ও একই কাগজ সবার গেছে
আমি দেখে নেব।
সবার একই কাগজ সবার
হ্যাঁ,
শুনে 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 আপনি আমাকে এটা আমারটা
Please give me your address.
he is possibly file a supplementary affidavit today.
three volume
Voluminous supplementary affidavit. We have recorded in the order also. See, we want to, the matter has traveled to through the court since 88 till the present proceeding. So decades. There are 3 or 4 relevant orders. One is the base order of the case filed in 88. Then 915 is another important order because His Lordship Justice Chakravarti has dealt with the matter in detail, tracing the entire history of the matter. So if from these pleadings we can find out that he has ever raised this claim, then we don't know. But if there is no such claim raised till now, let's see.
Item number 4.
Terms of your last order. I have collected the copy of the affidavit reply, which has been used before the court below.
Lordship, I have a strong objection to that. Because, Lordship, I have gone through after your Lordship's previous order, in fact, where my esteemed senior friend has wanted to rely upon this affidavit in reply filed before the Honorable Single Bench Lordship. I have gone through the entirety of the single bench order, and not a single order has been found out where this affidavit in reply has been taken on record, Lordship. Lordship, may I hand over a compilation of orders? It will be apparent from that one of the relevant orders. Lordship, but
Then how can you say it's not part of the record?
Lordship, this was never served upon me before the Honorable Single Bench, and also your Lordship can kindly takes up page 6 of my compilation, Lordship, of the compilation of orders which I have handed over, Lordship. The order dated 27th of July 2020, June 2022, Lordship.
Which compilation?
Compilation of orders which I have handed over, your Lordship. A very thin page 6 of the compilation, Lordship. The order dated 27th of June 2026. 2022, Lordship.
Oh, this one. Which order?
Lordship, page 6 of this compilation.
Yes.
That dated 27/6/2022, Lordship. The last paragraph of it, Lordship. Mr. So-and-so learned advocate today appears on behalf of Union of India and files affidavit in opposition which was affirmed on 10th March 2021 and also appears from the letter dated. This is one inadvertent error. This would be 17th of March. Instead of that, has been recorded that the copy of the said affidavit in opposition was served upon the learned advocate for the petitioner on 17th of March 2021.
Till date, no affidavit in reply has been.
Lordship, Now, if your lordship can kindly takes up a paragraph, third paragraph at page number 3, where the department has submitted a report before this honorable court on that particular relevant date. That
Paragraph 3.
paragraph 3 at page 6, lordship. That Vide report 23rd of June 2023.
Yes, in the last paragraph, the court has recorded. It appears that on hearing the
Also with the department, lordship.
department may say anything, the court has recorded a finding that is not, department is. So after that, how many dates?
After that, there has been, lordship, 20th of June
July.
2023, where the hearing has started before the honorable single bench, and 27th of June 2023, when the hearing was concluded. Before the
So what is it in the reply that will?
lordship, my contention is that this reply was never served upon me.
All right, so that is.
Second is that
But it
I
is, he has obtained a copy from the record, so that means it must have been filed by him. There is a certified copy. It's not that he's filing it. So if there is no service, you take a copy. We can allow you to go through it. If there is a objection, we understood. According to you, it was not served.
And I was not given an opportunity to raise all these points before the honorable single bench.
No, in rejoinder, if he has raised, unless he has raised something new, what can be done? Cannot. Why should we shut it out when it is part of the record? If it has not been served on you, there are two ways of, either we cannot take into consideration altogether. That once it is there.
My contention is that only, because my respectful submission to the lordship is that a pleading which was never part of records before the honorable single bench, before the trial court, lordship, should not be considered at the trial.
No, it is before the honorable single judge. You are saying it was not served on you,
Lordship,
which
but
we don't know whether it
that
was
is
served.
also not
Normally, what
from the order itself.
show us when you have served it on him.
Initially, my learned friend was not appearing. Subsequently, my learned friend.
When I say not served on him, means on this Mr. So and so.
I'm not on that.
When have you served on the other side? Show us. Who is appearing? You show us when you have served it.
I have to find out, because Mr. Pal is appearing in the advocate record in the court bill. He's advocate record. So,
you have come forward with a document saying that this was part of the record. He says it was never served. Show us when you have served it. And whether you have relied upon it before the honorable single judge or not.
Kindly accommodation for one day, I had talked with the court, advocate record of the lower courts.
Then you speak to him, then you come with this. You tell us.
One modest prayer subject to kind sanction.
Yes. Give it back. We are not accepting it.
Supplementary affidavit, Lordship.
What?
These documents to be placed before Lordship by a supplementary affidavit. If Lordship can take note of this point.
You have not filed anything today.
My Lord, I can hand it over, Lordship.
No, you give it to us after you ascertain whether it was served or not served.
Your Lordship, only just.
Not today, you find out.
Also, one thing is that, Lordship, the honorable single bench, there has been no orders which from where it reflects that this affidavit in reply was taken on record, Lordship.
That you have already said.
Lordship.
That you have already said. You have taken us through the order repeating it. Let him find out. If he has served, he has filed. Then we consider.
Would the Lordship place it on Monday, Lordship, or tomorrow?
Let it come tomorrow. We'll see. Yes.
So kind of. So kind of, Lordship.
Item number 5.
Item number 5.
Item number 5, my lord, I am led by Mr. Kosov Bakshi in this matter. He is
But I beg to appear for the petition, my lord, in this matter.
Yes.
Sir, I am appealing for response number 2 to 5. Oh.
Yes, you have.
My lord, in this matter, my lord, since my lord 2007-9-2002, 3-9-2002, my lord, this period, my lord, I was not paid for not the fault of mine. Your Lordship, you had taken up this matter on the last occasion, my lord. I had to take a specific instruction from the client with regard to this thing. My lord, all this thing, there was a several round of litigation. There was an order of transfer wherein I was posted to the northeastern region. Since my wife is was a cancer patient, I filed an application before the concerned Central Administrative Tribunal. Subsequent thereto, there have been several rounds of litigation, and thereafter I was once again posted to Baliganj. My lord, whatever my contentions were, practically that were admitted by the respondent authorities, my lord, on the premise that subsequently I was transferred to the Kolkata region itself. But the delay and the laches and lacuna which had taken place was completely on the part of the authorities. There was no fault of mine. I completely went on agitating my grievances before the appropriate forum. No, man, I leave it complete to your lordships because I do not have much to say in this, because that period I have not served.
Whoever it may be a fault, you are away for so many 2 years. You want regularization of a period. Therefore, we asked you to take an instruction whether any leave was available to his credit. If it was not available, how it can be regularized? Cannot be regularized.
Well, I leave it to your lordship's discretion, because I said that I have nothing much to say on this.
All right. Where is the speaking order of 7/1/2013?
Lordship, kindly come to page 68.
Well, that is 3rd January 2013. That is the speaking order.
No, 7 January 13.
Yes. 7th January
Not 3rd
2013.
January. It's 3rd January.
3rd/7.
Oh,
Well, 3rd January. That's 3rd January.
no, it's 3rd/7.
Sir.
Both dates are there.
No, well, that yes, madam, that is there at page 68. Page 68.
Correct. That is the order.
Yes. Well, earlier there was a round of litigation wherein my prayer for regularization was allowed by the concerned CAT, Central Administrative Tribunal.
No, but in the writ proceedings, it was held that you go and approach them for this.
No, my lord, kindly sees, my lord, paragraph 3 of the speaking order.
Yes. No, but this period is after the order passed by the tribunal in OA 211.
So kindly come to ordering portion of the speaking order, page 70.
Yes, we have seen that.
And that has been challenged in OA number 294.
Where is his application of 7/9/2000?
79/2000.
That is the application he filed on which the speaking order has been passed.
Yes. Coming.
This arises out of the order passed in OA number 317 of 2011.
Yes. Pursuant to that order, my lord, speaking order was passed. And challenging the speaking order, he has come up again. He went to London Tribunal, and my lord, where it was decided that Lordship kindly come to the ordering portion. It was delivered by Honorable Justice my lord Pratap Kumar Roy and my lord Mrs. Joya Das Gupta.
No, there is no direction. It is just that he will make an application for regularization and that will be considered.
The page 72.
No, we are looking at 66A.
Oh, achha.
66A is what he is referring to.
Oh. Oh, this is the REIT application which is preferred, my lord.
Arising out of that.
Yes.
This is arising out of
My lord, OA 317 of 2011.
yes. So tribunal has dismissed, then he approached the
Dismissed,
High
yes.
Court, then the High Court directed that he will file an application which
In
is to
straight format.
which was to be considered. After it is considered, reason order passed, then the present OA
Yes.
294 of 13 has been filed. There is no provision under which a person who is attending to a ailing wife can be considered.
That type of thing. Another 2 years unauthorized leave. This one 3rd September 2000 to 31st September 2002.
That we have seen. Yeah.
And then he didn't make any application even.
7 September 2000 to 30th September 2002.
Yes.
This is the period.
This is the period. And all the leave period, those were encashed by him. And no leave was,
He is retired now.
he is retired now.
Yes, yes, superannuated in the year 2011.
All right. Yes, please take down. The
My lord, may I have the occasion to listen to your lordship's order because it can't be heard, my lord.
your advocate is here.
My lord, my lord, my lord, my lord.
Yes. The
Item number 6.
Under the petitioner before your lordship, my lord appointed and or engaged in the railway establishment in January 1980 at Jamalpur. Thereafter, he has been transferred from Jamalpur to Howrah on the ground of surplus staff. He occupied a quarter at Jamalpur.
Demand for damage rent.
Yes.
How much? What is the period?
The period is, according to their calculation, 2001 from the day of my transfer from Jamalpur to Howrah.
Your transfer. You are for the writ petitioner.
Yes.
Please come this side, sir. We thought you are appearing for the railways. We are going to dictate that nobody is appearing for the writ petition.
He has transferred from Jamalpur to Howrah, Bandel. Sorry, Bandel. So in the year 2001.
2001.
He engaged in the year 1980 at Jamalpur. Thereafter, on the ground of surplus, he has been transferred from Jamalpur to Howrah. Sorry, Bandel. From Jamalpur to Bandel. Yes. Bandel.
Yes.
When he was at Jamalpur, he has been provided accommodation. But when he transferred from Jamalpur to Bandel, he has not been provided any accommodation.
No, you are not transferred. You wanted to come to.
So, due to ground of surplus, they asked me that you are surplus. Here you are surplus. That's why you file an option so that we can transfer you the elsewhere.
So you opted. You opted to come.
I have opted.
Yes.
Certainly I have opted. And I came to the Bandel. The quarter I have occupied, that is in Jamalpur. So when I have come to the Bandel, the government or the railway establishment did not provide me any accommodation or anything, whatever it may be. No accommodation has been provided. So therefore, the question is very simple. Question of whether he pay me the house rent allowance or he provided me the accommodation. For that reason, he deducted in a certain amount at the normal rate, as a normal rent. But he did not provide me. Since 2001, he did not provide me neither house rent allowance nor any accommodation. On the ground of surplus, they asked me to deployment. I made an option and I have deployed. They deployed. No doubt about it. My humble submission is this. Now, at the present moment, I have challenged that the damage rent they have collected from me that is totally illegal. Because under the Constitution state that any Article 20, Clause 2, that for the same offense cannot be punished twice. So, if the railway, I am asking only one thing. If the railway show me that either he provided accommodation since 2001 to 2010 January also, because I have been provided HRA after vacating the quarter. I have provided HRA from February 2010. So my humble submission is this: let the railway show that either for this period 2001 to 2010, either he pay me the house rent allowance, then I bound to pay the damage rent. If the railway establishment neither pay me the house rent allowance nor pay me anything, nor provide any accommodation, but they have deducted from my salary as well as my gratuity amount. I have retired. So, Lordship, I will turn to page 49. I have the railway establishment itself says that I am the surplus staff. Page 49 and page 51.
Page 46.
Page 46.
What is at page 46?
46 means prayer. With the tribunal. Only simple thing. Lord, either they show me that the house rent allowance has been given to me.
Where is your representation that you filed for
Yes, I have filed.
waiver of the damage rent?
Yes, I have filed. I have showing you, Lord. Sorry, Lord. First one is A8, page 68. Thereafter, details representation I have made. That is page, my lord. Page below starts from page 80. Details representation. Annexure A14. Page 87 is my relief, what I am asking in my representation. Page 87. Due to non-consider this representation, I filed a way before the tribunal. That is page 88. The order has been passed. Page 88, 89, 90. To consider my representation. Thereafter, on 6th June 2013, they passed a memorandum. Against that, I challenged before the tribunal, and tribunal passed the order. You also kindly turn to page 72. There is a letter of senior divisional personnel officer. He categorically stated that after clarification from the Jamalpur, that he has been transferred from Jamalpur to Bandel as a surplus staff, and the deducted amount will be returned in consultation with the accounts. That is page 72 and page 74 also. Yes, I am opted, but only because of this. They have said that the surplus stuff. Page 49, I have stated according to their record, page 49. Page 49 at the top. They himself said, I am the surplus stuff. Page 49 at the top.
Who is appearing for the railway in this matter?
Page 49 at the top. Your Lordship, kindly see. Annexure A. Market Annexure A in the tribunal. The tribunal page 22 that has been cut it down. Page 49, running
No,
page 49.
see, that is immaterial, whether surplus or on your own. How it makes a difference?
Yes, my lord.
What is the difference?
The difference means, my lord, due to the difference is deducted in page 71.
No, whether you have gone after being declared surplus or not, what difference it will make?
Yes. If I am surplus, my lord, then I have been posted somewhere, then the employer should provide me either HRA or accommodation.
Even if you are not surplus, then also you are entitled.
That is also.
So
If
therefore,
I'm not surplus, that is also.
So therefore, what difference it makes? It does not make any difference.
In
Surplus or not surplus does not make any difference. The point is, the quarter at Jamalpur you have retained. You have said your mother was undergoing treatment from 2001 to 2009. In 2009,
I have wrote a letter.
2009 you have written a letter.
2009.
That now the treatment is
Actually
over.
vacated 2010.
January 2010. Later you have written in July 2009 that now I am willing to vacate. So how can you hold on to a quarter like this? Under which provision you are entitled to?
How they calculate the damage range? Well, if I am
In your
agree, I am
in
agree
your
with that.
if
they provided me the house rent allowance
in your
or-
representation you have not said that you did not get quarter in bundle. In your representation, you have not said anything about quarter not being allotted in bundle.
No, that has not been allotted.
No, you have not said so. In your representation, you have not said so.
That I look into then.
We have gone through, therefore we are saying. We don't know. Come to page 68.
8.
Yes, that is the first representation. Even in page 71, you have not said that you are not allotted any quarter in bundle.
No, it is the duty of the employer to provide me.
Where who is saying you are not provided? You have not said that you are not provided.
No, the order passed. The order passed. They have not provided. It is admitted.
You have not said so.
In their reply also they have said. They filed a reply before the tribunal.
They have said that it did not.
No.
Where is that? Show us.
I reply before the tribunal. That starts from page 93, reply. At the bottom, that he applied for the same and finally he was selected, posted as Director Howrah Division in the year 2001. Let them say they have provided accommodation to me. No,
They are not required to say. They will dispute a fact only if you raise it. Unless you raise a fact, we are not going to call upon them to say anything. That's not your assertion in the representation. Why should we call them?
they have not allotted. It is
We
true
don't
they
know
are-
how you are saying. We don't know how you are saying. Unless your client had said in the representation, we don't know what is the occasion for you to say. And we don't know whether you have said in your OA also.
So Lord, kindly give me some time, my Lord, so that I can run through this.
No, we have gone through both the represent. Now come to your OA. Whether in the OA you have said, let us see.
Wait. It starts from
Yes, at page 32. Read subparagraph 5.
32.
Yes.
Yes, sir. The applicant could not get water at Bandel.
Therefore, we are saying you read it.
Find some difficulty, my Lord, I can't run through this. Because that is that I have stated, my Lord. That I could not provide it in spot.
Who is for the railway?
Yes, my Lord.
Who is for the railway?
My Lord, I don't know who is appearing.
Mr. Swapan Banerjee was appearing.
Government is earlier.
Yes.
He
His
is
name
dependent now. He is dependent now.
should appear.
Mr. Sabarmanji was earlier, but he is dependent now.
Hmm? Then you serve on them.
Once again, the whole repetition.
No, inform them.
I said
They have already appeared, so they
Yes.
must be having copy. If they
Yes.
don't have, they may ask you, we don't know. But you inform.
when your lordship fixed it on when, then I shall ask him to
When do
appear
you want? Tell us next week.
next week any day.
There is none to represent. You are appearing for railways, Mr. Rai. Please tell someone to appear in this case, whoever it is. We have fixed it on 22nd. Earlier, somebody was appearing, but now that person, we don't know whether he is.
Now, he has been dependent.
So,
I have stated
so he will give the notice to whom?
to the Ministry of Law. Ministry of Law. Ministry of Law. Ministry of Law wants 2 copies. Just a voluminous.
Then where we have said to, yes, we have said to intimate the advocate.
Seven.
My lord, I am being led by Indrajit Dasgupta. I am proceeding for short partial.
He is still in conversation.
15.
Tomorrow, not today.
Item number 8.
Item 8.
Lord, I am appearing for the petitioner as per Lord, last direction, my lord. I have already served, my lord. He is appearing, my lord, for the request.
So after invitation, he has come. Then let us proceed.
This is a matter, my lord, where, my lord, the petitioners were deprived of getting the MSCP
Increment.
scale increment, and because of the fact, my lord, that they have been given a promotion, which we have stated that it is a upgradation, not promotion, and on the basis of that, my lord, our my lord MSCP, which has been granted 9 years ago, has been, my lord, curtailed, and they have refixed our pay, and they started recovering our, my lord, from our salary,
So tribunal has interfered with recovery, but not fixation.
not fixation. My lord, thereafter, my lord, these 2 petitions, my lord, has been filed previously, my lord. They are, my lord, dismissed by the learned tribunal. These WPCT applications were filed, writ petitions were filed before this honorable court. In the meantime, my lord, one set of similarly circumstanced persons, my lord, went to me. Lord, I filed an application before the learned tribunal challenging that order. My lord, that application has been disposed of in 2025, directing that these are upgradations as per the judgment of the principal bench, and also as per the judgment of the which has been confirmed by the Delhi High Court by a writ petition, and following by a review application which has been dismissed. My lord, on the basis of that, my lord, the judgment has been passed, where these judgments has been placed before the learned tribunal, my lord, and my lord, earlier occasion, my lord, has Also, my lord, observe that it is also declared par inferior to the judgment declared by the my lord, other Delhi High Court and the principal bench. That is, my lord, I have handed over, my lord, the judgment passed by the learned tribunal in the other matter, my lord, similarly circumstance matter. Wherein
1239. 1239. OA number 1239.
Lord, that is 1239.
Yes.
1239 dated 22/4/2020.
So all these persons have got the same upgradation.
Same upgrade. All they are upgraded in 2003 by a, my lord. I will play if my lord wants. I will
By the same office order,
Same
0030.
same office order.
Office order number 0030.
Lord, that is
030. Yeah, 113.
113, my lord. Kindly see.
Page 113.
No. Lord, this is, my lord, that is page 57. The order by which we are given the
Upgradation.
upgrade. 57.
Oh, this is a policy decision.
This is a policy decision.
This is not the order giving you.
On the basis of which, my lord, we have been given the upgradation.
No, but the upgradation has been given on this basis on the same date to all.
To all, my lord, kindly sees the persons who are, my lord, that, my lord, the impugned order. That is page 68. Page 68, my lord, will find the person who, my lord, has got the relief from the tribunal is C.R. Mujumdar in the first, and his petitioner, my lord, Topon Raichaudhuri is in 4.
Serial number 4.
Serial number 4. And all the persons who are, my lord, named in this petition, my lord, has been, my lord, my lord,
benefit of
this notice covers all the
Oh, this is the impugned notice.
This is the impugned notice. After that, my lord, the recovery has been made. Recovery order, my lord, has been passed at page 130. Based on this, 130. And the main order, my lord, this is a, my lord, phenomenon which has been taken place throughout throughout India. My lord, this is not a case isolated to the CLW only. My lord, this is not, my lord, isolated to CLW. This is, my lord, challenged before the principal bench. My lord will find the same or the order of the principal bench at page 186.
First of all, Lordship, I am begging pardon for the last occasion I could not appear. I was
Not only last occasion, last two occasions. We have twice sent intimation, invitation. Then you have
yesterday the matter was called on, my lord. I was on my leg before court room number 8 and simultaneously matter was called on, Lord.
anyway. But see the situation.
Lordship, I have gone through the documents that sent to me, and I have gone through the orders of the principal bench as well as of the High Court, Lordship. Since the affidavit have not been exchanged in this matter, Lordship, I asked the department to send me written instruction in the light of the judgment of the Delhi High Court and of the principal bench, Lordship. I am seeking for some time to got the written instruction.
And this way also, way 1239.
Yes, Lordship. Yes, Lordship.
Come back in a week or so.
Lordship.
This benefit has to be granted to them.
Lordship.
The learned.
आज की फॉर्म আজকে 23 থেকে 20 দিন সময় আছে। 23 তারিখ সময় দিয়েছে। Respondent seal টা হ্যাঁ ঠিক আছে।
Item number 9.
9, my lord, also same, my lord. These two are, my lord.
You are appearing in 9 also.
Yes, lordship.
Same order.
9.
For the state. I'm for the state election.
The state is also a party.
I have got a paper from the GP office. 9.
কি ম্যাটারের নাম? নাম কোন ম্যাটার?
Vishwanath Ocha.
বিশ্বরূপ ওঝা।
Vishwarup Ocha.
হ্যাঁ,
Right. জানি না আমাকে একটা পার্ট দিয়েছে তো বিশ্বরূপ ওঝা বলে আমার কাছে আছে না,
You see your petition whether state is not party. Then why? All right, call the next.
Okay, all right, your lordship. Grateful.
Item number 10.
Yes,
I'm applying for respondent number 1, 2, and 4.
1, 2, and 4.
That in this matter, my lord, I tell your lordship what has happened. My lord, the original applicant before the tribunal, my lord, has expired during the pendency of the matter. Now, my lord, substitute. We are the Union of India is the petitioner before your lordship. Now, my lord, since the incumbent has expired, so we were required to file substitution application. Accordingly, we filed. Now, my lord, some of the respondents are appearing, save and except one. Time and again, we were asked by your lordship to serve the non-appearing respondent. We have served. Again, we have prepared an affidavit. The endorsement of postal department says the concerned respondent has left. So this is the situation. What I am on, subject to your lordship's kind decision, the matter can very well be disposed of without appearance of the non-appearing respondent, for the reason, if your lordship kindly, I will just show your lordship only 2 pages. First, the impugned order, if your lordship kindly sees, the tribunal remitted the matter before the revisional authority for taking decision. And the original applicant was directed to cooperate with the revisional authority. Now, since the original applicant has expired, now the question of cooperation by him doesn't arise. Thing is this, the revisional authority took a lenient view and the punishment was reduced. The original punishment by the disciplinary authority was removal from service due to continuous 2 years unauthorized absence. Now, removal of service, appellate authority confirmed that order of punishment by the disciplinary authority. He preferred revision before the revisional authority. Revisional authority took a decision that by some kind of mercy, 2/3 pension was granted in favor of the original applicant.
That
Now,
decision is after the tribunal's order.
no, before the tribunal's order. Being aggrieved by that order also, the original applicant preferred the original application before.
He wants full pension.
2/3. If your lordship kindly.
No, the applicant wants full pension.
Full pension.
He has been allowed 2/3, but he wants full pension.
So if your lordship takes a decision, subject to your lordship kind decision, since the matter is being adjourned on repeated occasions, due to non-service upon the non-appearing respondent, I would only submit before your lordship, 2/3 amount we are prepared to grant. Widow is there. Her son and daughter is also there, who are being represented by him. One share may be kept with the railway authority if in the meantime, after disbursement, if non-appearing respondent comes to us, we shall pay her.
No, but if they are agreeable, otherwise if they are contesting the 2/3 and they want full pension,
That's
We'll have to hear
But
out the
who would cooperate? Well, tribunal's order, if your lordship kindly
That
says-
order has become infractuous.
that order cannot be acted upon because the person concerned has left the world. Now, my lord, who would go to cooperate with the railway authority?
That is provided they want to comply with the tribunal's order.
Right. So, my lord,
Oh, they have not challenged the order.
no, they have not challenged. We have challenged the order. So, my lord, it was specific direction. Where if your lordship sees the last page,
Then it is.
the revisional authority will complete his exercise within a period of 8 weeks from the date of receipt of a copy of this order
No,
and
but it-
issue a reasoned order untrammeled by his earlier orders dated so and so.
So we asked you whether the revisional authority has passed the order after the disposal of OA. You said no.
No, it was remitted. The tribunal
Upon remission, it has been made
Yes.
2/3.
Yes. No. But revisional authority took a lenient view and 2/3 was granted in favor of the original.
That was
application.
assailed in the OA.
Yes, that was assailed.
And in the OA, what was the direction passed?
Yes. The OA was disposed of with a direction. Last page, if your lordship sees, Lord, since Lord, the conduct of inquiry Lord, was not properly done, therefore, Lord, the revisional authority will complete his exercise within a period of 8 weeks from the date of receipt of a copy of this order and issue a reasoned order untrammeled by his earlier orders dated so and so. While the revisional authority proceeds to take actions in terms of this order, the applicant is directed to cooperate with the respondent authorities in the process. Who is going to cooperate?
And before the court, the wife and one son and daughter is
One
here.
son, one daughter is not appearing.
One daughter is not appearing.
So her share can be kept with us. Let her approach to us. We shall pay her share. Other shares will 2/3 according. Now, my lord,
So
what is-
your rate petition has become infructuous.
that's correct, my lord. That's correct. And the order passed by the revisional
There
authority.
is the
which-
question of passing any order now.
If your lordship sees page 46, let them agree to that. Page 46. That is the order passed by the revisional.
This you are not telling us till now. Therefore, we are asking you.
But kindly see page 46. We are ready to comply with this. Page 46. Right. Lord, last paragraph, please, Lord, kindly see.
But according to you, this revives.
Yes. This revives.
So therefore, what remains in the writ petition? What will you get from the writ petition now? You tell us.
Certain directions so that this thing can be complied with because the original applicant is no more.
Yes.
But, since the contesting original applicant is no more in the world,
Yes.
then let us comply with the revisional authority when the applicant existed. That is my only prayer.
See, we have a matter fixed at 1 p.m. We will consider it after recess.
After. All right. I will come back. শেষ করে দিন শেষ করে ফালতু সার্ভিস ওর শেয়ার রেখে দেবো আমাদেরকে তেলে ভালো নাহলে আমরা খাবো এই
আরেকজনও আছে ওনার নাম দিয়ে দেবো তোর পকেট থেকেও পয়সা যাবে না আমার পকেট থেকেও যাবে না তোর অসুবিধা কি আছে
Supplementary list 1. My lord, I am for the petitioner, my lord. My lord, the case is, my lord, an advertisement was floated by the West Bengal Health Recruitment Board for appointment to the post of grade 3 medical laboratory assistant. My lord, previous years, my lord, this post was advertised. Also, previous year I applied. My qualification is diploma. This is what they want. Diploma in grade 3 lab. This is my qualification from West Bengal's laboratory, my lord. This is what is called lab. It is written. My lord, I have got my qualification from West Bengal Council of Technical Education. the authorities wanted that it should be a state university. It is a state university. My lord, previous year I was not allowed. I approached the tribunal. The division bench of the tribunal passed an interim order allowing me,
Where is
and my lord, that order is at page 53.
ultimately কি হলো সেই মামলায়
সেই মামলায় disposed of
কি মেনে নিল?
যে বসবে। My lord, if your lordship kindly comes to from page 54, last paragraph, may I read for your lordship, page 54. Dictionary is same.
No, but there is no adjudication that it is an equivalent.
My lord, no, there is no adjudication. Thereafter, my lord, by the previous order, I am
When you mentioned the case, you told us that there is an order holding it a valid.
subsequent order, my lord.
Show that.
Page 57.
This was irrelevant. So far the present year's concern, let him show that the order passed on the basis of his
57,
way
the state
application.
authority stated that we have allowed. The way was disposed of. Subsequently, this year advertisement was floated.
Then you made a wrong mentioning. You made a wrong mentioning today. You told us that in the earlier proceeding, it has been held as equivalent and a valid.
It was held.
It has not been held.
My lord, the authorities accepted it.
Then they will consider. Then
My lord,
where is the
only one
question?
thing, fourth is the next.
Can be done, sir.
My lord, only one thing comes for my satisfaction. Kindly come to page 7. It has been admitted. The tribunal admitted my petition.
Yes.
And did not pass any interim order.
Yes.
My lord, tomorrow is the, if I ultimately succeed, my lord, previous year I participated.
Where is the qualification
My lord,
prescribed?
my qualification is.
Where is the qualification in the advertisement?
My lord, advertisement is at page 63. My lord, the chart I am applying for the medical technologies lab grade and qualification, my lord, Roman 2. Diploma in medical technology, the concerned subject recognized by the state clinical Institute of West Bengal under the West Bengal paramedical officer conducted by and recognized. My lord, your lordship has got that. Now, my lord, kindly see my certificate at page 47.
This is for only one post or several posts?
No, my lord.
Only for medical technologies grade 3.
My lord, your lordship has see the chart, my lord.
Yes.
Medical technologies lab grade 3.
First one.
First column, my lord. The vacancies are
total 633.
Yes.
And where is the qualification for this post?
Just below it is qualification. And my lord, Roman 2 is your lordship kindly sees. And this is my ground of rejection, my lord. It is not on the question of equivalence. Why I was rejected.
Where is your qualification?
Page 47. 47 is the mark sheet and 48 is the.
Neither of the two documents are legible. We cannot read.
47. 48 is certificate. Your lordship is certificate. And that is page 48. আরেকটা copy.
একটা legible copy.
My lord, round of rejection, your lordship kindly. At page 68. At page 68.
দেখো 2 years এর ডিপ্লোমা ইয়ার লেখা থাকে না
সার্টিফিকেট আমাকে তো ইকুইভ্যালেন্সের জন্য কিছু বলেনি। I have been rejected that this is not a state university. It is a statutory body under state of West Bengal.
No, the requirement as per the advertisement is the diploma must be in medical technology.
Yes, medical technology in the concerned subject, my lord. Kindly see.
In the concerned subject.
My subject is laboratory.
And it has to be recognized by the state medical faculty of West Bengal.
My lord, this is.
Where is it saying that it is recognized by the state medical faculty of
rejection
West?
at page 68 is a rejection which is the subject matter of the my lord way tribunal. Page 68 is the rejection.
Yes.
Which was challenged. Rejection is on this ground that the institute is not affiliated.
No, it is on both grounds. It is not affiliated and state to any recognized
by the HRB administrator detailed is not affiliated to any recognized universities / state medical faculty. At
so therefore we said state medical faculty of West Bengal. There is no recognition. We are asking you state medical faculty of West Bengal. That is specifically stated in the qualification.
Subject to correction, my lord. Medical faculty or recognized university.
So there is no university also.
No, ওখানে নয়.
Neither this is fulfilled all the
অ্যাডভার্টাইজমেন্টটা কত পাতায় দেখালো?
Yes.
University which provide
advertise
there is no
এটা ধরো তো
we don't know. Then you should have challenged the advertisement.
No, my lord. They are the advertisement, my lord. I am coming to the advertisement, my lord. Please.
Yes.
My lord, I am reading.
at page 60.
In the concerned subject recognized by the state medical faculty.
So it is not recognized by the state medical faculty of West Bengal. It is not that not institution, sir. Recognized institution affiliated to any recognized university. But this is not affiliated to any university.
It does not.
AICT is a university. AICT is a university. Technical education is a university.
This is all India. This course is recognized. There's no other course.
Where have you said there is no course recognized by any university in the state of West Bengal? Show us.
I have stated that AICT is the only.
Please see, you are making all kind of submissions in here. First you made a wrong mentioning. Now again you are making false submissions.
University the no.
Just now you said there is no university. And when we are asking you to show it, you are not showing it. That we have understood. Take down. Sorry.
বলতে তোর
How many times you will say the same thing?
I apologize, my
Yes.
Considered the plight, my lord. If I
No plight. Either you are qualified or you are not qualified. It's very simple.
NCT না national.
We don't know. You should not, Mr. You should.
যেটা অল ইন্ডিয়া কাউন্সিল অফ টেকনিক্যাল এডুকেশন
not my intention. I was of the wrong impression. My lord, since government accepted that, I was of the wrong impression. My lord, I was of the wrong impression.
Submissions is not at all appreciated.
ওর আন্ডারে হবে
You are not of the wrong impression. You had read the order. Don't say you are of the wrong. How can you think when you are mentioning after with the brief in your hand? You have gone through everything.
মৌলানা আবুল ও আব্দুল কালাম আজাদ যেটা ওইটা
Yes.
They conducted examination, everything under All India Council for Technical Education. My lord, this is the body which gives affiliation to all Indian.
Just take instruction.
Well, I shall take instruction.
Come back at to 3 p.m.
3 p.m.
Find out if just allow him to sit. We don't appreciate, sir. We don't appreciate false submissions in any case. It always goes against your client. It always goes against your client.
Order it's my mistake.
Item number 10.
We are just going through. Give us 2 minutes. So what is the effect of the order? You are getting the 2/3.
Third, my lord, I tried to contact my client, but I could not contact. So for instruction, I need 1 week. That is one thing. But my lord, if my lord goes to the impugn order, the initial inquiry that should be set aside because notice for ex parte proceeding was not given.
You are not in the writ. You are not the writ petitioner.
No, I am not writ petitioner.
You
but
have
I'm supporting
accepted.
this.
You have accepted the tribunal's order. The
My lord.
tribunal has said that the revisional authority has to consider the procedural aspect.
My lord.
So at best, you can claim nothing beyond that. And now that you are
So far
not
as
there,
that 2/3, that I have to take instruction.
so
Whether
therefore we are asking you if you are getting the benefit of 2/3, then we'll see what order is being, because the tribunal has not interfered with that order. So you must be getting it.
that I tried to contact my lord during recess, but I could not contact.
They are getting it. You have got any instruction?
Can I read the letter? পাচ্ছি কিনা সেটা জানার চেষ্টা করছি। আমি কন্ট্যাক্ট করার চেষ্টা করেছিলাম বাট ফোনে পাচ্ছি না ক্লায়েন্টকে। পাচ্ছে কিনা সেটাই। না পেয়েছে এটা দিয়েছে দেখুন the case was held on election situation as record.
As per record of the legal error, it's drawing compassionate. You say that the legal error is drawing the compassionate allowance. Which legal error?
We do.
You don't say in the letter.
The widow is getting the allowance. As per my instruction, taking the instruction, we are getting the allowance. Full benefits.
You are getting it as per their
As per they are saying, but
what but?
necessary order may kindly be passed because the petitioners are suffering because during the this is pending since long.
Are suffering. They are saying you are drawing the pension. You are saying they are suffering. The unique submission is given.
But they wanted more. That cannot be.
No, but who is drawing that we want to know because now that there are.
That, my lord, I can say that the widow is right because they have the sons and daughters have come later. The widow was always there.
So maybe she is drawing. Most probably she is drawing. So just tell us this and we'll dispose of the matter.
My lord, I just kindly keeps it on Monday.
Item number 11.
This matter, why it is being adjourned again? Really, it has been- My God. Yes. Yes, who is for the Union of Home? Are you getting the subsistence allowance? Are you getting any amount?
No, nothing. Subsistence allowance, nothing.
How you can get subsistence? You are the son of the employee. So how this order is to be complied? How you can participate in the inquiry?
If there is no inquiry, my lord, let my pensionary benefit which should be released.
No, but this order is, you have obtained this order.
My lord,
You are the applicant.
my lord.
So how do you propose that the order will be executed? You say that you should be allowed to appear before the disciplinary authority.
This is a consent
How
order.
the son can appear before the disciplinary
This
authority?
is a consent order. Now against that order, they did not prefer any petition. They
Yes.
preferred a review. Review was dismissed, but it was time barred.
Where is the review order? You have filed an opposition.
No, I have not filed any opposition.
Where is the review order? Show us.
And your lordship kindly see the order. My lord, review order was.
Is it on the record?
Yes. Lordship kindly come to কোনো প্রেজেন্টেশন গুলো করে না পেজ 34 34 of the application. Review application is dismissed due to time bar.
Which orders? So which orders they have challenged in the present writ?
I am appearing for the union in this.
Review order as well as the order of 13 June 2019.
Your Lordship, I am led by the learned ASG in this.
Yes.
And your Lordship directed
Yes,
to
Your
file the status report.
Yes, why have you not brought the status in terms of the last order?
Your Lordship, we have received the status, Your Lordship, but Your Lordship, the learned ASG is engaged elsewhere, Your Lordship. So Your Lordship will kindly give me some time. We'll get it, Your Lordship.
What time? If you have
Kindly
already
pass.
received it, come with it tomorrow.
No, your Lordship
We'll come with it tomorrow. We'll come with it tomorrow.
Before vacations, I cannot get time. After vacation. Yesterday they failed. Today they failed. After vacation. They let them get a sufficient time.
All right, list this matter
Your
after
Lordship,
the
learned ASG.
applications.
I'm grateful to Your Lordship.
নামগুলো দিয়ে দিয়েছো তো?
Your Honor, I'm for the petitioner.
And for the respondent, my lord.
It will have to be in part.
Lordship, there was a direction by your lordships on the last occasion to bring some precedents by the petitioner, my lord.
Yes.
Regarding the
My lord, there
family pension of the
was precedents as such related to this particular, my lord.
We thought so. Therefore, we were just giving you an opportunity. Because you had argued on merits, we said that if you find some law, you can place it.
Only which I can one indulgence, my lord, that the rule has to be considered in its entirety, my lord. Only the particular rule 6 was considered. Rule 6 was considered instead of rule 11A. Only a portion of the rule was considered. The tribunal ought to have considered rule 11A, which it was not considered by the tribunal. It should have considered the rule in an entirety. Only a portion of it has been considered.
TCS pension rules. TCS pension rules. TCS pension rules दिन लाए थे. नया वाला लाए. हाँ.
The page 69 to 77, the relevant pages of the rule. 69 to 77, we have annexed it.
Rule 11 is at page 76.
76, my lord. Rule 11A is at page 76. And rule 6 is at page 72. Rule 6 taken into consideration by the tribunal is in page 72, and rule 11 is at page 76.
Keep look.
Yes, Millard, I appear for the writ petition. Millard, the facts in nutshell, Millard. This is for only for just recapitulation of your lordship's memory, Millard. Millard, we, the deputy director of the Unani Medicine, Millard, is a petitioner, Millard, who was transferred in the year 2013 and which became, Millard, the subject matter of a challenge before the Jammu and Kashmir High Court. The initial, the order of transfer was stayed. Ultimately, Millard, the same was dismissed. Millard, the interim order was vacated and the petitioner before your lordship preferred an intra-court appeal. The appeal court, Millard, granted liberty to the petitioner that go and approach before the single judge.
Transferred in 2013. An interim order passed?
Immediately thereafter they approached. Now, Millard, thereafter it was vacated in the year 2014.
2014, the OA was rejected.
Interim order, Millard,
only was vacated.
Now, Millard, I preferred an intra-court appeal before the division bench. The honorable division bench said, go and approach before the honorable single bench. I approached, the interim order restored to its original file. Be that as it may, after the...
By the tribunal?
No, the basic single bench, Millard. High Court single...
Oh, there it was before the single.
Now, Millard, what happened?
When it was reimposed? When they...
Reimposed, Millard, that is 2014. And...
No, 2014 is vacated.
Oh. 2nd May 2014, the order was restored, page 98 of your lordship's brief.
2nd May?
2nd May 2014.
And what is the date on which it was vacated?
Vacated on 5/3/2014.
So a very small period.
Yes, small. Now, Millard, I approached, Millard, that was restored. On and thereafter, Millard, on 11th August 2015, this was withdrawn because, Millard, my client said that he should be given a liberty to join Kolkata, where he was transferred. I joined. Now, what happened, Millard? Millard,
withdrawn on 11/8/15.
Yes.
Joined in Kolkata on
24th August 2015.
15, same year.
Same year.
So he complied with the tribunal order, the transfer order.
Complied with the transfer.
Yes.
And within the time, Millard, needless to mention, within the time stipulated by the court. Millard, that is, there is no delay. Now the dispute cropped up, Millard, when I made a representation to the authority that for a particular period, Millard, I was not allowed to sign an attendance register, but I discharged my duties.
Where?
Jammu and Kashmir during the period of this writ petition appeal. Regional Research Institute of Unani Medicine, Srinagar.
So that period is from May 14 to August 15.
That is, Millard, the representation is at page 40 of your lot. 30 October, Millard, the transfer order was made 19th October 2013. My representation before the authority after joining, Millard, that was made on prayers for arrears salary, which was, that is, Millard, the applicant.
Your Lordship, I have made a small list of dates, Your Lordship.
Page 40 of your Lordship's brief, Millard, that is the representation. Right? I prayed for my arrears salary, Millard. And the same was rejected on 8th December 2015. Page 40 of your Lordship's brief.
What is the order of 27/11/14? What is the order passed on 27/11/14?
75, Your Lordship.
11.
Yes.
875. It had set aside the order dated 15/11/2014, wherein we were directed that his release the salary and the directions were passed upon us to release the salary. That has not been annexed by the petitioner. 1511 order has not been annexed by the petitioner. So we had preferred an appeal, and the appeal court had passed this order.
My arrears salary, my lord, which I paid, my lord, 19/10/2013 to 23rd 8 2015. I paid for the arrears salary. Now, there I get my case before your lordships is that, my lord, I was not allowed to put my hands on the attendant register, but I discharged my duties. I have given a proof, my lord, from the RTI application and, my lord, certain outdoor tickets, which is at page 114 and 115 of your lordship's brief, that the authority said that yes, 114, I attended the OPT.
So the first demand made by you is at annexure A5, page 40.
Yes. And which was rejected, my lord, page 41. I preferred appeal, my lord. The same was also rejected, page 43 and 45.
Yes.
Now, my lord, I have given an evidence to the extent page 114 and 15. My lord, the 115 is the question I sent to the authority under the RTI Act. The question was very specific and the answer is also very specific. That is, my lord, 115 and 114.
Where is the answer?
Answer is 114. Question 115, answer 114. Now, my lord, the Additional Solicitor General, my lord, my learned senior friend, my lord, had raised a question that these were not on record before the tribunal. My lords were of the prima facie view that whether law permits me to take this point before the WPCT for the first time, when admittedly, my lord, these were not placed before the tribunal because these were the question cropped up.
So this is the admitted position.
Admitted position. Now, my lord, I have, my lord, certain authorities in my hand, which possibly, my lord, lends meaningful assistance to decide the list between the parties, and the answer is in the affirmative. (1993) 4 SCC, because if your lordships take note of, my lord, the page 114, this was obtained on 25th August 2023. My lords had taken note of this. The impugned order was passed on 27th March 2023.
So this is after the tribunal.
After the tribunal. Sorry.
Then that is not much of any.
No, that is why. So I am armed with the authorities, which says even if that is there, the answer is, my lord, the Honorable Supreme Court said I can raise this point before your lordship. Since, my lord, I am covered, so I need not trouble your lordships with the judgments. Since, my lords, the question of denial, my lord, whether can arise that the claim that was rejected, tribunal proceeded on the consequences, the impugned order, that I could not, my lord, give appropriate evidence which could inspire the confidence, and that is why the tribunal rejected. And my lord, I am sorry today because, my lord, I am not armed with, my lord, the 2 copies of the book for which I tender my unqualified apology. 93 4 SCC, I will hand up the books for page 10. 93 4 SCC, page 10, para 12. May I have the liberty, my lord, to read for this paragraph, for my lord's kind consideration? I will hand up the book. In the facts,
Please.
I'm sorry, my lord.
Yes, please.
In the facts of the case, there was not only a reasonable apprehension in the mind of the appellant about the bias of one of the members of the inquiry committee, namely the said Sri Maruram, but such apprehension became real when the said Sri Maruram appeared as a witness against the appellant to prove the said charge and thereafter proceeded with the inquiry proceeding as a member of the inquiry committee to uphold the correctness of his deposition as a judge. The learned single judge, considering the aforesaid facts, came to the finding that the participation of Sri Maruram as a member of the inquiry committee has vitiated the inquiry proceeding because of the flagrant violation of the principles of natural justice. Unfortunately, the division bench set aside such judgment of the learned single judge and dismissed the writ petition improperly, to say the least, on a technical ground that the plea of bias of Sri Maruram and is acting as a judge of his own case by being a member of the inquiry committee was not specifically taken before the deputy commissioner and also before the appellate authority, namely the commissioner by the appellant. As such, the said plea should not be allowed to be raised in the writ proceeding. More so, when the case of prejudice on account of bias could be waived by the person suffering such prejudice. Generally, a point not raised before the tribunal or administrative authorities may not be allowed to be raised for the first time in the writ proceeding. More so, when the interference in the writ jurisdiction, which is equitable and discretionary, is not, of course, a must, as indicated by this court in M. Ellison versus State of Assam, particularly.
Oh, here the circumstance is different. This document has come into existence after there was no question of.
Yes, I am sorry, Miller.
So this may not be required.
Miller, yes. Yes.
So where is the order by which you withdrew the matter from the?
I was sorry, Miller.
You withdrew the matter from the Jammu Kashmir High Court.
Yes, I withdrew. Granted.
Where is that order?
That is, Miller. Applicant, page T8. Since my lords have just now observed that these facts are different, and since it was much after the, not much after, the 2 months after the, now, my lord, in this judgment, the only paragraphs which I, Miller, the sentence rather, the court says, Supreme Court says, but if the plea, though not specifically raised before the subordinate tribunals or the administrative or quasi-judicial bodies, is raised before the High Court in the writ proceeding for the first time, and the plea goes to the root of the question and is based on admitted and uncontroverted facts and does not require any further investigation into a question of fact, the High Court is not only justified in entertaining the plea, but in the anxiety to do justice, which is a paramount consideration of the court. It is only desirable that a litigant should not be shut out from raising such plea, which goes to the root of the lease involved.
This is para 12.
Para 12. So this part, the very next sentence. Now the question is, Miller, the RTI, Mr. Chakraborty, my learned esteemed senior friend, at no point of time Miller said that this document is ingenuine. The RTI application, that the response is not correct. No Miller denial with any morsel of proof. So Miller facts admitted need not be proved. And Miller, the lease is only confined to the extent that October 2013 to 2015, I discharged, and not only that, my duties and the OPD tickets, which I have annexed in the petition, page 111 to 113, which would go to show that that I have discharged my duties. It is a state within the meaning of Article 12. It's a model employer. I have discharged my duties, and my salary, this is a kind of exploitation, or whether I am permitted to say, this is a kind of punishment without there being any element of misconduct or proceeding. With denial of a salary is a punishment, and such punishment, at the same time, it touches my dignity, that as if I have some educational qualification, I am holding a an important post, and there is no any allegation with regard to any corruption or any misconduct against me, and as if I am begging something or seeking charity or compassion from my employer. This is not a case. If that is not a case, if there is no proceeding against me, then according to my humble understanding of the reality and law, it instigates me to make this respectful submission, subject to what my lords will say, that this is absolutely a punishment, unwarranted, and interdiction of my lord's court, is necessary. And tribunal, the question, Mr. Chakraborty, my learned esteemed senior friend, possibly, if my memory does not betray what my learned esteemed friend will say, had possibly, tried to persuade your lordship that whether I should have gone for review. Review is also not permissible,
Review of?
Review of the order, impugned order. Instead of coming to your lordship, whether, I should have approached the tribunal, under the review procedure. Why, review is not permissible? 2008, volume 8, SCC, page 612, paragraph 35. 2008, Roman 7, the Honorable Supreme Court has taken pain, to discuss, the power of the tribunal, vis-a-vis, the power which emanates from, the Order 47, Rule 1, rate with Section 114 of the CPC. I need not, create any trouble for your lordships to go to the entire 35, Roman 7. May I read for my lords? While considering an application for review, the tribunal must confine its adjudication with reference to material which was available at the time of the initial decision. The happening of some subsequent event or development cannot be taken note of for declaring the initial order or decision as vitiated by an error apparent. Admittedly, I got
35.
Yes, 35, Roman 7. Page, 638. So my answer, my humble attempt to respond to my learned senior friend's query, that why I did not approach the review court. 2008, volume 8, SCC, page 600, relevant paragraph 638, 35, Roman 7. So, today, first of all, this is not the case before your lordships by the respondent, the answering respondent, that there is a delay in approaching. There is no violation. I was granted liberty to join. I joined. 11/8 to 23rd/8, 24/8. Within 13 days, I joined. I joined Kolkata. The interim order that was vacated, and it is not my case, that I was sitting idle, at my residence, and I did not discharge my duties. Had it been so, the authority, could have. It is not the case of the authority that by reason of my alleged unauthorized absence, there is no case that has been made out, which amounts to misconduct, no show cause, no disciplinary proceeding, because I was armed with an interim order granted by the Honorable High Court. So the matter of reimposition, it, says that the interim order was there. And the liberty that was granted to join, they, allowed me to join. There was no, whisper. There was no whisper of the wind that, yes, we should not allow you to join. So you allow me to join. You allow me to work. And the moment I asked for my previous area salary, you said I will not give you.
So in between October 2013 to August 2015, there was no occasion to claim any salary. There was no occasion for the petitioner to claim any salary.
I did not claim, my lord, because it is not on record. But the question is, my lord, that this is also not a case, my lord, that arrear salary is a continuous cause of action. Your lordships, my lord, many have come across judgment that arrear salary, it is a continuous.
No, that is not the issue that we are trying to indicate.
Because
It's
nobody.
not a question of delay.
No.
So from October 2013
yes,
to August 2015,
yes, it is.
You
my
were
lord,
serving without any salary.
I served without any salary during the pendency, but this is, but had it been a case, my lord, the authority said, the department said I have discharged. But fact, my lord, remains that, my lord, it is also not a case. My lord, my silence in this regard, my lord, is possibly, if it is not barred by limitation, if it is not, my lord, amount, if it is
We
not.
ask you this question.
Yes, but that is true. I cannot.
Because
It is.
Please read page 39 of the brief.
Yes.
Please read page 39, last paragraph.
Compelled him to for seeking annulment of the transfer order. These writ petitions, along with the connected, are disposed of. It is provided that in case the petitioner join within 2 weeks from today, Kolkata, then the complainant will take lenient view in respect of intervening period, ensure no severe punishment is inflicted on the petitioner, and intervening period does not constitute break into service. The petitioner shall be allowed to join at Kolkata.
So the Jammu Kashmir High Court has taken care that no punishment is to be inflicted for this intervening period. The Jammu Kashmir High Court has further taken care that there will be no break of service. These two issues have been concluded. Third issue has been left for them to decide regarding the intervening period. That's the only thing. So you are saying that they have not conducted any proceeding. They could not have. The High Court has already held that no proceeding is to be conducted.
Right.
The High Court has held that no break in service, but decision to be taken regarding this period.
Right. So, my lord, if that is so, my lord, ultimately punishment has been inflicted upon me by not giving my salary. That is my say. Withholding or non-payment of salary, this is, my lord, a kind of a punishment, and that punishment without any authority of law. Now, my lord. Because there must be a finding with regard to my unauthorized absent. There is no finding, and if they arrive at such finding, there must be a proceeding. Not on the date, my lord, when such liberty was granted, 39.
No, the point is, sir,
because severe punishment. But there is the finding.
What is more severe than depriving a salary?
I'm extremely grateful. I said, my lord, that even, my lord, that is why I'm saying that you did not come to a finding, even if there is a finding on your part, and that too without any disciplinary proceeding. That means you have given punishment without any authority of law.
That we have understood. You are saying that this amounts to a punishment?
Amounts to punishment.
And this punishment could not have been inflicted without a proceeding. And you have work which is evidenced from page 114 given under the RTI Act. Therefore, there is no dispute
and they
also.
did not say that it is a fake or manufactured.
Obviously, they have issued it. How can this?
Lordship, we do not know whether the RTI is genuine or not. We have never said that it is genuine.
No, but they have filed it. You have not denied or disputed.
We have not filed. This is subsequent in only in the writ
They have filed it here. You have chosen not to file any reply.
We were not given an opportunity to file an objection.
What do you mean not given an opportunity?
We were not given an opportunity to file an objection to this writ petition.
You have been appearing for the last so many dates. When did you ask for filing an opposition?
Your Lordship, but this, Your Lordship had asked me to take instructions on the same. We had taken instructions. The authority have also informed that he has never worked. This is in writing. We have taken instructions that
the issue is not whether he has worked or not worked. The issue is whether that document is genuine or ingenuine.
Regarding the RTI,
whether that will satisfy the court's conscience that yes, he has worked. Whether that will not satisfy, we don't know. We are on the legitimacy of the
Milord,
document
I
only.
sent it to Srinagar,
With reference to the
near
RTI,
Nasimbagh campus. My affidavit of service discloses to the Branch Secretary, Government of India, Ministry of Law, Director General, Central Council, Unani Medicine, New Delhi, the
why are you
in charge.
with
giving
reference
this?
to the RTI, I had taken this instruction from my
Don't give
client.
us your mail. Why do you hand the mail, which is a privileged document between you and the
Your
client?
Lordship, this is,
of the Evidence Act.
Your Lordship, in that they have specifically stated
don't
he
know.
did not work.
That's not the issue. That is your consistent stand.
Lordship, how he
You
has
say-
taken this RTI reply,
You
that
say
has
not
also
work.
been disputed.
You say not
this
work. He
RTI.
say work. We are only on the issue whether that document you have disputed that it is not genuine.
Your Lordship, we do not know. That inquiry has to be done. We do not know. I have taken.
Inquiry has to be done.
Your Lordship, the department has to look into it whether this RTI has been issued under what circumstances.
Who has issued the RTI? Have a look at it. And which department will examine?
September 23, this was.
And the appellate authority has issued this. We specifically, I asked my client in writing to give me instructions regarding the RTI, to which they have stated that this is procured by him in some manner, this is not genuine, and he did not work. In writing, they have informed me.
See, he has not worked, is again and again we are telling you. Where have they said this is not genuine? Please show us that one word that this is not genuine. Show us.
It is requested to submit that the Honorable Court that Dr. Yunus Iftikhar Munnis was employed in Srinagar from 1993 till 2013. During his tenure, he established numerous professional and personal connections in the region. On the basis of his connections, even if it is hypothetically assumed that Dr. Munnis was present at Srinagar office during the said period, there is no official record or intimation of his presence communicated to the council by the authorities at Srinagar. After being relieved from Srinagar on 2013. Moreover, Dr. Yunus remained unauthorizedly absent from duty until he formally joined Kolkata in 2015. In this connection, it is pertinent to mention that the joining and relieving of an employee of the council is strictly governed by the orders of the competent authority at council. Further, if an employee, contrary to the orders of the competent authority, remain present at a unit of an organization based on a personal and professional connection without any official directive, such presence does not constitute an authorized discharge of duty. Furthermore, such unauthorized presence does not entitle the employee to salary, benefits, or any claim of official posting.
So we don't find the word ingenuine used.
Your Lordship, he has.
And we don't appreciate such submission being made without any written instruction that I have got a written instruction to
Your
this
Lordship,
effect.
with his connection, it is.
Please try to understand what we are saying. You made a submission that I have written instructions that it is ingenuine. Therefore, we asked you to read.
This is that they have written that with his connections, he has obtained it.
Why should you make such a submission contrary to the record?
They have submitted in writing that with his connections,
It is not submitted. We have asked you to read. We have allowed you to read. There's not even the word ingenuine has not been used there.
Lordship, he did not work.
Again and again, we are telling you that two are two different things. We are not on whether that will satisfy the court as regards his service. We said, what is the legitimacy of the document? You say that is a written instruction. There is no such instruction. Why should you make such a submission?
Lordship, written instructions are only limited to the point that
just 10 minutes back you said I have written instruction that is ingenuine. You use this word. So we asked you to please read where it says ingenuine. This is not the way. We would rather rely on what you say than to ask you to read everything to verify whether what you are saying is correct or not.
I had handed over the email. And
we don't want to see. Neither we are required to see. Neither you should give it to us. That's a communication between you and your client. Why do you give it to the court? This is not appreciated. We understand you dispute that he did not work. We don't know what is the veracity of that RTI, whether it will satisfy us to hold that yes, he has worked or not. That's a different thing. You said that you have written instruction, it is ingenuine. You have no such instruction.
I apologize, Your Lordship. My misreading of these. Yeah.
What is it there? Your stand is that he has not worked.
Your Lordship.
You want to file anything in opposition to the RTI? We'll allow you.
We want to file it.
Yes. take down. Let the learned
item number 1.
Today is, my lord, all the department of the state governments are closed. Today is a state holiday, but still, my lord, I have tried my level best.
Today is a state holiday.
My lord. But despite that, I have tried my level best and I inquired the matter. Now, my instruction is that it was of 2021. The recruitment that, my lord, notification and or, my lord, the invitation, that was of 2021. Now, my lord, at that time, my lord, this clause was there regarding that qualification. Now, my lord, I have to take some time. It will take some time that to ascertain that actually that so far this, my lord, the West Bengal State Council of Technical Education, where from he, my lord, obtained the diploma, whether it is, my lord, affiliated to that or not, as per this, my lord, the condition. But it will take some time. But in the meantime, my lord, my instruction is that either, my lord, because so far tomorrow's, my lord, examinations to be conducted, that is, my lord, only for those candidates who, my lord, filed, my lord, the court case, either writ petition or way. My lord, it is for those, my lord, that pursuant to direction of the court, I am told, tomorrow's those candidates. Now, my lord, I am also told that, my lord, that this type of, my lord, interviews are being held my lord, when matters are pending and if there is an court order, then even after the, my lord, the scheduled date of interview, on the there would be any next day for that particular candidate. So no problem if the, my lord, the issue what is presently before your lordship or before the, in, my lord, the tribunal, if it is decided in either way, if it is decided.
But when the process will attain finality?
My lord, this process is going on, I am told, in 2021.
So if you need time, then you allow him to participate.
Yes, my lord, there is also no difficulty that, my lord, that subject to that, his participation will not give any, my lord.
Obviously, at this stage, how neither he will claim nor we will say.
Yes, subject to the result of the.
Yes, mistake. What is that?
kindly don't keep this in your.
Sir, that is,
mind, my lord, this is
I
my
tell you
mistake.
personally for myself.
My lord, this is my mistake, my lord. Kindly don't, my lord. I am learning, my lord.
That is over, but I'm telling you one thing. This is personally, that's the way I am. I don't like any false statement.
My lord, it was not, my lord, it was my misunderstanding.
Worst case, you may succeed. You may have
No, my
the
lord,
best case, you may lose because you make a wrong.
Absolutely
I
correct.
don't appreciate wrong submission at all. Whoever it may.
My lord,
It is my, I don't know, shortcoming. It is.
your lordship is correct, my lord. It is my misunderstanding that has.
So it is over now.
My lord.
And I don't carry anything.
My lord,
when I
deeply
come
obliged.
from
Deeply
there.
obliged. Get. Mr.
Your Lordship, before the matter, I'm making my unconditional apology because yesterday I did not submit properly.
Which one?
You know, the next matter, item 14. Actually, I was not correct with regard to the scheme being adopted by the whether they are eligible to fall under the old scheme or not of pension.
Oh, yes, it has been withdrawn. He has shown
Yes,
us that
because
it
they
was.
are not entitled to.
Yes, no, you gave it to them, and then
then
all
we-
of a sudden you said that no, we are withdrawn.
Because the cutoff date in the scheme, government scheme, was they had to apply it before 1st of January 2004.
Before Millard,
He may state his case.
yes, Millard, there was an advertisement in the year 1997 by the Railway Recruitment Board. Now, Millard, the petitioners before your lordships, Millard, we responded to such advertisement. We participated in the selection process. Ultimately, we found, Millard, the panel was cancelled. And after a long battle, Millard, and and in the meantime, Millard, the second selection process, next selection process, when it intervened, the court granted, a tribunal granted liberty to my client that go and approach. Millard, be that as it may, ultimately we lost. We came before your lordship's court. The honorable division bench, Millard, had passed an order, Millard, with certain directions. That is, Millard, 29 January 2014. Where is that order? The order of the division bench.
Page 38, volume 1.
Volume 1, Millard, 38. Right. Right. আমরা কি এটা আছি না এটা আমাদের না তো
Yes.
Yes. Now, my lord, I started my journey from 1999. I was appointed on Millard as a sequel to this order, Millard, or in pursuance of this order from March 2014. Now, I made a representation to the authority, Millard, that the notional benefit, Millard, so far as the pension part is concerned, should be given to me. Now, the court in no uncertain terms said, Millard, that the recruitment rules 1997 will govern and the vacancies as available today. Millard, these are the two sentences possibly, Millard, I have found, subject to what my lords will say. Now, Millard, while court, what is the presumption, Millard, I put this question, while court granted this appointment to us, Millard, the court found, that is undisputed, that there was no laches or negligence on our part because we were not sitting on the fence. We, Millard, continued with our struggle and battle, Millard, in this court and the tribunal. It is the railway authority, Millard, because of their inaction or their wrong action, Millard, we denied our appointment. We were denied appointment. There cannot be any midway, Millard, either this or that. So the authority, the court, while granted, Millard, the relief, the court was quite conscious of the fact that the denial was unjust. Had it
Yes,
not,
we have recorded your submission. The submission of the other side has also been, you were supposed to give a reply.
Yes.
We have recorded the entire submission. You made your submissions that it was an administrative inertia on their part. Therefore, I cannot be penalized for this. The High Court has directed
and indicating that loss suffered by me and my juniors who were appointed subsequent to the same the next notification, they are getting, Millard. I said that I cannot, even if
you want no, even if you accept no work, no pay, you want notional benefits from there,
so that I can give the increment. Otherwise, the pension amount is, Millard, that is very. And I wanted, and the promotional part, Millard, which was due and they have fallen, Millard.
No, that is not part of the writ. That is not part of the OA. We are not going to enlarge the scope. If we grant, then everything will fall in place. If we don't grant, then nothing.
Two or three judgments, Millard. One judgment, Millard, sorry.
You are appointed on which post?
Millard, that is TCRC, Millard, ECRC, reservation clerk and Millard, inquiry cum reservation clerk.
Inquiry cum reservation officer. So how promotion can be taken up in this?
Millard,
you are seeking notional benefits, length of service from a particular date.
Yes.
So that is something else that has to be considered
Otherwise,
with reference to many things.
So automatically consequential relief, Millard.
If you get this,
if your lordships are with me on this code, then Millard, the others will follow.
That's why we say we don't know, as a result of this you may get promoted.
Millard, I wish
we
to
don't
rely.
know, as a result of this you may not get promoted. But nonetheless, that's not something which is to be considered in these proceedings.
Yes. Millard, then Millard, kindly give us space, Millard, while disposing or dismissing, I do not know. Millard, the only question, Millard.
That we have understood. Whatever is
Millard,
not
the judgment, Millard, that is Millard 2022 SCC online, Delhi 2699. No, Judge.
We are not referred to the paper report.
I have given 2 copies. Millard, this judgment was, I am told, I do not know, Millard, I am not sure. This judgment was handed over, Millard. I or not, I do not know. 2022 SCC online.
Then it must be here.
If it is not here, then Millard, I have to.
What is the name of the party?
Millard, name of the party is Ajit Kumar Chaudhary versus Union of India.
We have it.
Yes.
Delhi.
Yes.
Delhi High Court Division Bench.
Paragraph 16. Millard, here, Millard, in Ramesh Kumar's case, Millard, the court says that in normal circumstances, when retrospective promotions are effected, all benefits flowing therefrom, including monetary benefits, must be extended to an employee who has been denied promotion earlier. So far as the monetary benefits with regard to retrospective
So
promotion.
therefore, you say the moment we retrospective appointment is given, we must be given all the benefits.
Otherwise, my lord, I said, my lord, arrear salary I cannot claim. I cannot because I did not work. But the question is, my lord, because, my lord, otherwise notional benefit, my lord, if your lordships.
Promotional benefits are given to a person who is already born in the service.
I was not born in the service because of their negligence.
So therefore, can you draw a parallel of this benefit with promotion? You're relying upon a decision which has applied this retrospectivity with reference to a promotion, a person who was already in service.
Yes.
Whereas what they are trying to say and what they have argued is that till such time a person is born in service, he is not entitled to anything.
Yes. I was not born in the service because of their, because I tell your lordship.
No, that you have said, because of their inaction, they wrongly cancelled the recruitment process.
Not only that,
Only because the High Court came forward that you got the appointment.
And not only that, the High Court was conscious of the fact that the recruitment rules, my lord, govern me, my lord.
97, yes.
Not the otherwise. If at that point of time, if the pensionary benefit was there, so government committed no mistake by allowing me to cover under the original pension scheme. Now the government says that it is a mistake, there was a cut-off date. In the affidavit, now my lord,
So what is your reply? They have relied on a judgment. We had asked you, we had given you time to give a reply. They have relied on a judgment. 2024 SCC online SC 1768. You were here on that day.
No, on the last occasion, my lord, I was on a virtual mode.
8th August 25.
8th August 25, possibly, my lord. I was on a virtual mode and the paper book was not, my lord.
So you were virtually present.
I was in a virtual mode. I could not, my lord.
No, we have recorded the entire submission in that order.
Yes. No,
and we have
I
recorded.
appeared, but I may not. Yes, I was not there. I could not follow, my lord.
Could not follow. We have recorded your submissions.
What is the judgment?
Bihar State Electricity Board versus Dharamdev Das. We had fixed it for your reply. For submitting a reply by Mr. Basu. Submits the matter may be listed under the same heading next Wednesday. Your submission.
Reference
go through it. Go through it.
Sorry,
go through it. Everything else you have argued. You go through the earlier order of this court of 8th August 25 and then you give your reply.
Monday, may not possible.
As prayed. List on Monday. And please go through the order of 8th August.
Yes, yes.
I have prepared a
Notes
of argument for your lordship. Should I hand over to your lordship?
What is it?
Notes of argument giving page number of the paper book. It will not help us.
Just a minute.
Please can copy the.
It will be according to the paper book page we have prepared.
My lord, 8th August or the order passed dated 8th August, my lord, it is yet to be uploaded, my lord. It is there. That is, my lord. E-codes showing that.
And after that, the next order has been uploaded.
Yes. 13th August order is available, no?
That's right. Why is it not been?
13th August available, 8th August saying that. আছে এই দেখো এটা দেখে নিন না, it's not available.
বলছেন তো সার্ভার হয়নি।
Not sir.
Why?
তুলে নিয়েছি ছবি।
That's right.
তুই ওটা পাঠিয়ে দিবি তো? যা লিখে সেই যে 10 নম্বর কোটা আমরা দেখে নিই যে বাইরে আছে।
Matter of 15.
But in place of 8, we not 9 possible. 9 possible. My junior has written. 9.
You want a 9?
Yes. Sorry, my lord.
9.
Deeply obliged. I'm sorry, my lord.
And we are sorry that is
No.
he said it was in the court. Be done today.
Actually, I could not follow on that date, my lord. I was not here. I was on a virtual mode.
Matter of 15.
Yes, we had heard you on virtual mode.
My lord.
We had heard you on virtual mode. Yes.
ইকরামুল বাড়ি উইথ appear on behalf of the petitioner, my lord. But due to his personal inconvenience, আছে না চলে গেছে। না।
What do you want?
My lord, in this matter, I am for the private respondent number 1 and 2. Private respondent number 1 and 2.
I am for the country. I wish to appear on behalf of the government in the petitioner to the Russian to challenge the order of the tribunal 12th of September 20. Fine. Good evening. Reply. Thank you.
You are filing reply.
That temporary time.
2012. Yes.
December 2012, applicant respondent number 2 applied for
When did he apply?
December 2012.
Yes.
2015. The government rejected the prayer for completion. Principal Secretary rejected the prayer.
Oh, you are not appearing for the respondent.
Yes, my lord. I am for
This case?
Yes, madam. Respondent 1 and 2. 19. On the basis of mutual condition, calculation, even if we take 2008 circular or 2013 circular, 90% of the total income.
Annexure কে আছে? মেমোটা আছে কে? 2013 মেমো কে? ও যেটা চ্যালেঞ্জ করেছি? এই 61টা দেখুন, হ্যাঁ ওইটাই 61 থেকে স্টার্ট। এটা
Statement in terms of the order of the capital, page 61.
Yes.
Government consider it including financial conditions. The learned tribunal had that income retirement benefit cannot be considered. But giving appointment on compulsion ground in view of Govind Prakash Verma. Govind Prakash Verma subsequently impliedly overruled by the
Okay.
only two things. Income slab, miscalculations, actual figure was not mentioned, and we have particular.
Where is the judgment? Govind Prasad Verma, Govind Prakash Verma.
So Verma, but 2019 volume 3 SSC page 653, paragraph 15, 20 and 23 and 33.
No, it is 2005 10 SCC.
This has been impliedly overruled.
No, where is that judgment? 5 10 SCC.
That has been implied. That we discussed everything.
What are you doing?
Okay, judgment. Can you see paragraph 15 first? Yes. I will also got it at page 662. The High Court was dealing with the first issue. Paragraph 15. High Court was dealing with the for decision held that the state is not entitled to take into account family pension, other terminal benefits in determining whether compulsory appointment should be granted to the dependent of the assembly. In coming to the conclusion, High Court has relied upon a decision of the state Govinda Prasad Bharma versus LIC and two subsequent decisions of such and such not entitled to consider the family pension or other terminal benefits received by the dependent. High Court has held that the income class which is discussed do not constitute a development that constitutes that compression. So that we can see paragraph 20. The terms of the policy, we are of the view that the High Court was error issuing a mandamus government to disregard the policy. Such direction could not have been issued by the High Court. The High Court has drawn substance in issuing mandamus in the above terms of petition of court of Govind Prasad. That was a case of compulsion where this, in the course of proceeding before the High Court, a learned judge has directed license to stop. For completion appointment observed, officer what inquired completely omitted to furnish a report on the point which we had got. High Court rejected the petition on the ground that the family receipt of family pension other amounts towards terminal benefit. Regarding the case, the High Court had been Govind Prasad in order totally irrelevant for department authorities to the learned judge. Separate decision, but before we award the decision, it is necessary to note that the grant of compulsion appointment had been considered case of Umesh Nagpal, the original judgment. That is 794. The principles which have been laid down in Umesh Nagpal have subsequently followed consistent precedents of the court. This principle and adopted as followed. Then Mala kindly paragraph 33. Since we have come from the High Court was justified based on the decision of Govind Prasad in issuing direction to the state in acting manner.
Paragraph?
Paragraph 33.
33.
That the High Court was not justified based on the decision of the Govind Prasad in issuing direction to the state in acting manner contrary to the term of the direction of the state in that manner of the scheme which required the family pension received by the dependent be taken into account.
So it has not been overruled.
Impliedly overruled.
No, no.
Considered. considered?
Not overruled. It is in a different circumstance. In Govind Prakash Verma, the court directed to find out who are gainfully employed.
Yes.
They came back with the sum of family pension.
Okay.
Then court said, no, we'll not consider this. We did not ask you to come with this.
Yeah.
Here, the court is saying that the scheme will prevail.
Yeah.
If the scheme requires family pension to be considered, it will be
Yes.
considered. If it requires otherwise, then.
Yes. Can you see our
So Govind Prakash Verma has not been touched.
our scheme is family pension has to be considered.
No.
No, income family pension.
In your scheme.
Yeah.
So what is there in the format? The three-member committee which examines the case, they have to fill up a format of all the
Yes.
relevant parameters.
Income.
So where is that?
Can you see 2008 circular?
Huh?
2008 circular?
Format.
No.
Page.
Pension.
Yes.
Now, can you see the date of date is 16 July 2012. And 2008 circular, page 37. This was prevailing at that point. One of the conditions that needs to be fulfilled for offering a permanent or compulsion ground is the family of the just employee or permanent retired employee, be it the immediate pensioner. Here, prior the family of the just retired
Subclause A at the bottom.
pension per month, basic generous pension, etc. Monthly interest at the rate of 8% of the total by the family after the death of the employee. Then monthly income.
No, the next A, below that. The monthly income of the family shall mean aggregate of total family pension per month.
Total family pension per month, basic generous pension and relief, etc. Then monthly interest at the rate of 8% of the total amount received by the family after the death of the employee or retirement, incapacitated employee, deferred gratuity, leave encashment, provided had to incur medical expenses as injured patient prior to leaving his death, incapacitated such expenses may be deducted from the amount received. All the expenses must be supported by original receipt, cash memo, hospital discharge certificate. The family members are expected to submit a declaration on the matter. The monthly income of the dependents of the ex-employee, then with the application, members are expected to submit a declaration in the matter.
So here also the scheme requires the family pension received by the dependents to be taken into account.
I'm grateful to that. We have considered it. Page 77.
Page? Yes, 77 you have just placed.
Page 61.
You have that format which is to be filled up by the three-man committee. Because, or the format on which he has applied. Where is that format? That format is prescribed in the EMP.
Yeah.
In which EMP that format is specified?
2008 and 2013.
In both.
13 circular, page 71. Application submitted in the prescribed format externally and be applicable to head office or accompany copy of the death certificate.
কিনা জানিও না, রেখেছে কিনা তাও জানি না। আমি না জেনে কি করে বলবো? ওকে সেটাই বলবো যেটা আমি জানি।
Page 63 calculation sheet.
No, that's not the point.
Where is the format? You have the format. It is there in that compilation.
Format.
All right. Anyway, you are relying upon the 2008.
2008 and 2000, whatever, because same thing is there.
Yes.
To consideration of this fact, one thing has calculated as follows.
Yes, that is not in dispute. He is saying that it cannot be taken into consideration.
That is not been disputed by me also. But my lord, one thing, my lord. My father was died due to stomach cancer. And a huge amount has been spent on behalf of my father, my lord. But my lord, it is my also fault. That is the bill and receipts has not been protected by me. So I cannot produce the same. Now, my lord, I am coming. The state has taken 2 memos at a time. Both the memos are not equal, my lord. 2010 and 2013. My lord, 2008, I am drawing my lordship's attention to page 77.
Page 70?
77, my lord.
Yes.
Well, just my lord, I am first. Yes. 76, starts from 76. Page 77. My lord, here is what happened, my lord. Basic and dearness pension both are separately calculated. If so, my lord, in the 1981, my basic was P2000 basics will be calculated according to 2008. Because P2008 basic has not been counted with DP. DP has been counted separately. I'm giving the seat, my lord. And 2000.
I could not follow what you are saying.
Yes, my lord. I'm just pressing, my lord. One calculation sheet, my lord.
No, what calculation is not required. Only thing is whether family pension is to be considered or not. That is all.
Well, part of the family pension has been considered.
Part of it has to be considered.
My lord, family pension, these the P81 has been basic calculated separately.
That is not the point.
2013, my lord, I'm just a second, my lord. Enhancement basic pension will be calculated as basic pension. Enhancement basic pension, my lord, there are 4 categories, my lord. One is basic, another is, my lord.
Basic is not relevant. Total family pension is to be seen.
Not, my lord, in the, my lord, that has been categorically mentioned, my lord.
Huh?
2008, my lord, in the bracket, categorically mentioned which are coming into the calculation. Page 77.
Yes.
I'm reading it, my lord.
Yes.
77. That is, my lord, 3 second day. Total family pension per month, my lord.
Total family pension.
My lord, within bracket, basic, dearness
Yes,
pension.
basic, dearness pension and relief, all.
And relief.
All.
But, my lord, fitment weightage is not be counted.
Huh?
Fitment weightage.
Fitment.
Yes, my lord. My lord, I'm placing the memo, my lord. If my lordship kindly allow me, I'm placing the memo. There is a pre-2008. At 2013, my lord, 2013, the enhanced basic pension total has been calculated at basic pension.
What are you saying? At the time of demise, there was a different pension?
No, my lord. Pension
At the time of demise of
No.
the employee, the
No,
pension.
6675, my lord. Enhanced pension has been calculated as basic pension. As basic pension. This is the fact. And my lord, 45% of the year. Dearness relief. 45%
Then
of
we
the
are,
dearness relief.
then what are you submitting? We are not
Then
able.
actually, my lord, what's happened, my lord, according to the calculation, my family income is 5,000 more than the required.
5,000.
5,000 in excess more than the required, 90%. But my lord, my father was a cancer patient. So 8% of my terminal benefits, into 8% interest of my terminal benefits, that has also been calculated, which has been spent for my father's treatment. I am just praying before my lordship only to consider that portion. Joseph দেখে দিচ্ছি। Page 81 এখানে 81 টা আমি ইয়ে করে দিয়েছি। পেজ 81 মনে হচ্ছে 81 তো শিওর তো? পেজ 81 আমি একটু বলে দিই, স্যার।
We have seen that, but he is not arguing. We have seen that in many cases, but he is not arguing. And what he is arguing, we are.
My lord, provided that where an ex-employee has to incur medical expenses, page 81. Page 81.
So therefore, you are not arguing this. That expense was required to be deducted.
Yes, my lord.
But you say you have nothing. Then what can be done?
My lord, I'm not expressed in.
You
proper
said
manner.
that you have spent, but you have nothing to show that you have spent. So if you have nothing to show, then how it can be deducted? Then who is at fault for that?
But actually, my lord, I have no.
Who will suffer for that? That is the point.
Actually, the family has suffered, but my lord, I have no.
We don't know. If
I
you
have
are
no
suffering, you would
grievance.
have kept all these things very carefully.
Yes, my lord.
Normal conduct is that someone who
Yes, my lord,
suffers,
this
he
is
will
my
keep
fault.
all these things very carefully.
Poor family, my lord. So
That's why we are saying
yes, my lord. Yes,
such persons, they are
Yes,
very
my lord.
careful.
yes, my lord.
Only someone who is not,
Deeply obliged, my lord.
but you have nothing,
my
then
lord,
what can be done?
But my lord, but my lord, he has been treated. His treatment is going on.
We don't know.
Allahabad.
We don't know.
My lord, one death certificate also, my lord.
We don't know. You have not, whether you have said in your original application. Show us from the original application that you have taken this ground.
My lord, give me 1 second.
Original option starts at page 21.
What is the date of death?
Date of death is
July
2012.
Where he has undergone treatment. Mr. Where he has undergone treatment.
At Allahabad. Allahabad, sir.
So it is very difficult to get a
My lord,
copy of.
kindly allow me to file one supplementary affidavit, my lord. I have 2 or 3 papers are with
We are
my
not going to evaluate your claim. If you have anything, you can go and show them.
My lord, kindly allow me next week.
No, why
I'm
next
trying,
week?
my lord.
If
2 or
you-
3 papers I have.
Page 41 is the death certificate.
No, we have seen he has stated that he died because he was suffering with stomach cancer. He has said that in the OA. You come to page 36 of your brief.
Proposition দিয়েছি?
Come to page 36 of your brief, sir.
Yes.
Roman 7. So you go and show them. If you have anything, then you may get some benefit. Otherwise,
But we have said so in the affidavit that no document was submitted.
so if he can show something, we don't.
That has to be placed before the authority concerned.
Correct. Before the authority concerned, yes.
And authority concerned has considered everything. Page 53. The death took place at Siliguri, West Bengal.
But treatment was
At Siliguri.
but treatment was done out of Bengal, my lord.
একটা পেপার আমাদের ছিল সেটা ভালো বোঝা কোথায়
Eight. Yes, 36, paragraph 8.
Yes, where is your, in your application, have you sought this relief before the authority?
ইজিটা আমি তো কোথাও বলিনি ডিডাকশনের কথা That permitted pro forma report of the experts committee, copy of the death certificate, citizenship certificate, education certificate, certificate, employment exchange card, and identity. Page 45. Now, only point to be considered by your lordship whether family pension could be calculated taken into consideration for family calculated number.
Lord, one amendment has only made, my lord, page 30, paragraph 18. But without any documents, my lord, I am admit. Only amendment has been made, my lord. My lordship has got it. Page 30, paragraph 18, my lord.
No document was placed before the authority.
What can be done? You have no document, then how? It can't be done on assumption. Cannot be done on assumption.
It should be. My lord. So you know,
yes,
my lord, only one Sunrise nursing home, my lord, only one page has been annexed, which is issued by the Sunrise Nursing Home Private Limited. Nursing Home Private Limited. Page 64. Excepting that, nothing. No, what is the apartment?
Death certificate.
Annex করিনি.
This is a death
Plus
certificate.
now it is 13 years. Now it is 13 years. Death is of 2012. Petitioner has not bothered to raise this claim before them for 13 years. Can be done. And that judgment which the tribunal has relied upon, we have already seen. Yes, we'll pass the order tomorrow. Parties have been heard.
5,000 is more. My lord, admitted position. And for his treatment, my lord, something.
It is admitted position.
Stomach cancer. Patient
Admitted.
has stomach cancer. Yes, my lord. Yes, my lord. The annex.
They have admitted.
From the death certificate annex.
They have admitted.
Death certificate and annexed.
So death certificate means their admission.
No.
Don't say admitted position.
But the affidavit we filed today, we kept it there.
Affidavit in reply is kept on record.
I'm deeply obliged.
17.
In 17, my lord, I am for the petition. কপি দিয়েছে তো আর পড়েছে দেখো এটা দুটো জজ দিয়েছে দেখো
আমরাও একটা অ্যাফিডেভিট দেখব
না ওনার সাথে চিন্তা আগে হতে দরকার
Filing a reply.
Yes.
What is the issue?
This matter is related to that land.
Land
This
user.
matter is land user matter, my lord. And my lord, the challenging the judgment of the Justice Holy Standards Division Bench, my lord, before the Supreme Court review petition was filed. And my lord, all other matters was lawsuit was pleased to fix on 29th of November, my lord.
Already fixed.
No, your lordship is pleased to fix the other land user matter on 29th of November, my lord, due to pendency of the review application before the Honorable Supreme Court, my lord.
29 November.
On my lord, this matter may be also fixed on the 29th.
Cannot be 29 November. Some other date, sir.
9th November.
29 November is a Saturday. Maybe October. It was not so far. We had kept it after the holidays.
October is a holiday.
29th October, my lord.
Holiday.
No, no, holiday তো।
ছট পুজো আছে।
আর এখানে আছে 29th of
ছট পুজো আছে।
না, না, next 29th of holiday।
29th
other এগুলো।
the calendar 29th আছে রে, দেখ না।
হ্যাঁ আছে স্যার, কিন্তু ওই সময় ছট পুজো হয়।
কিন্তু ছুটি সেটা
না, না, ফিক্স করেছিল
না
কোন
করো, 3 তারিখ করো। 3rd November, 5th November।
Yes.
My lord, after reopening, my lord, any date, my lord.
29th, what is difficulty?
We will have difficulty. State gives a holiday, High Court doesn't have a holiday.
Yes.
We personally will.
We are informed that these several orders
না না
Similar
ওর নাম মে
My lord, 90 to 22,
same matter.
24,
25
25, 26.
See, unless the lawyers are here, we will not pass any order.
22.
আজকে হবে না কালকে হবে ছেড়ে দাও
Let the learned advocates be here.
পিটিশনার অ্যাডভোকেট নেই
Just now note down the date so that we know the date.
10th of November
10th of November. Only this case.
দিচ্ছি